dedicated to promoting climate literacy within the legal profession. And so we can't do that without collaborators and other experts such as resource people from SDPI. So this is the first time that the High Court Bar is collaborating with SDPI, and I'm very happy to see a lot of familiar faces because we do a lot of these events at the bar. So I'm happy to see especially a lot of young lawyers as well, join us. So we're going to begin shortly. I would actually like to request some of our other speakers. We have Justice Sufyan Rana. He's a district judge. Judge Sufyan Rana. He's a district judge in Manchester, and he's here from England. So, sir, if you can please come up on the panel and join us. We also have Barrister Ghazan Mahmood. He's also a Deputy District Judge from England. And welcome to Islamabad, first of all. So thank you very much. If I can also request the Vice President Qazi Adil Saab to also join us. He's the Vice President of the Islamabad Bar Council. So very important role. Vice Chairman, sorry, apologize. Very important role as the regulator. We also have Mr. Umar Sumro. He was the former law minister in Sindh. Please, sir, if you can join us as well. Thank you. We will like to formally begin. If we could maybe start with the recitation of the Holy Quran, and if we can play that. Thank you very much.
Bismillahirrahmanirrahim. أحد
So I'd like to begin by actually requesting Dr. Abid Suleri, who's the Executive Director at SDPI, for his opening remarks. And then we will move on to Emily Morrison, who's joining us online from the International Bar Association, for her remarks as well. Sir.
Thank you, Sarah. Good morning, and a very early good morning to Emily, who has joined us online. Sorry, Emily, for this delayed start. I know it's only 6:30 or 7 o'clock in UK time. But thank you very much for taking the trouble to join us and be with us virtually. Sustainable Development Policy Institute, we are the oldest independent policy think tank in Pakistan. It was established back in 1992. And at that time, it was National Conservation Strategy that Pakistan has to formulate. And one of the recommendations of National Conservation Strategy was to have an independent policy think tank that should work with government and not work for government. And we are working with government. We introduce ourselves as a shadow cabinet. We work in almost each area, every area of policy making. And our work with government is pro bono. Of course, we have our development partners, different UN agencies and different bilateral agencies. But with government of Pakistan or with any provincial government, our policy advocacy work is pro bono. We do feel that STPI and legal fraternity, they have a very close bonding. And all of you would be familiar with the Shala Zia versus WAPDA case. And if you look at one of the co-applicants in that case, you will find Sustainable Development Policy Institute. So SGPI, since the beginning, has been trying to provide research-based evidences, not only for policy making, but also for contesting those rights in the superior courts of law. STPI has been serving on various judicial commissions on environment and climate change. STPI team has served as a amicus curiae to the superior judiciary on various matters. And it is in this context today marks extremely historical and significant moment for me personally, hosting and inviting and hosting, welcoming Islamabad High Court Bar Association. Thank you very much, sir, for accepting our invitation, joining us here. We do feel that bar, bench, and research fraternity, this is a combination which is need of the hour today in all matters, but especially in climate change and environment, which for many remained a hoax and a rumor till a few years ago. For some presidents, it's still a hoax and rumor. I'm referring to a US president. But then rest of us, we are observing it happening, and we are the victim of climate change, where one can see the changing and unpredictable seasons, how they are affecting our daily lives. Now, I am a firm believer that natural calamities cannot be stopped. They're bound to happen. But with the right set of policies and practices, those natural calamities can be stopped to turn into human disasters. And that's where your role becomes extremely important and significant. Which policy? There is no good or bad policy. As a public policy student, I keep telling that there is no good or bad policy. Every policy would have some beneficiaries. Every policy would have some losers. But the role of decision makers, the role of judiciary, the role of bar is to maximize the beneficiaries of any particular policy, reducing its negative impact. And that's where evidences, they come handy. Now, while those evidences and the research, it feeds into the legal cases, it's also important to understand that in today's world of artificial intelligence, producing evidence is no more a difficult thing. You can write anything on DeepSeek or ChatGPT 4.5 or Perplexity, etc., and you will get a perfect answer. We have been taught and told, listen what is being said, don't look into the fact who is saying it. With this artificial intelligence, I think who is saying it has become extremely important. Everyone can say now, everyone should say. The right of speech, freedom of speech is for everyone. But in order to then turn those statements into credible evidences, we also have to see that who is saying it. And that's where STPI and institutions like STPI, we are not the only one in this country. Of course, this place is full of these credible think tanks and credible thinkers, thought leaders. So our this redefined role is to strengthen the evidences and arguments of bar, as well as provide support to the bench. And in that context, I'm extremely thankful to my seniors, Honorable Justice Mushir Alam Sahab and Justice Jawad. Justice Jawad, I must say, is a dynamic force, and he has been supporting the researchers and research and independent research throughout his career. So we had requested Justice Jawad Saab, we had requested Justice Mushir Alam Saab to visit STPI, be part of us. And with this, it's an extreme delight to host our three international guests here. We have with us District Judge Sufyan Rana. We have with us District Judge Barrister Ghaffran. We have with us very renowned lawyer from UK, Miss Emily Morrison. And of course, then we have our guests, Umar Somro Saab and Kazi Sahab, and all of you who are here. So this is just the beginning to invite you to visit STPI. And we'll be joining by Ms. Rumina Khurshid Alam as well, who is the coordinator to Prime Minister on climate change and environment. She would be here in next 10, 15 minutes, and that's where, when you will find me, I'll leave my chair for her and I'll come and join you. So this is the broader context in which I wanted to welcome you. STPI, Sustainable Development Policy Institute, we have a team of around 120, out of which we have around 65 researchers, out of which we have around 10 to 11 PhDs who are working here full time on different issues. So you can take us as this single window center for any of your research work. We'll be more than happy to collaborate with the bar and provide you with whatever research support we can provide, preparing the evidences that you require for preparing public interest litigations, the evidences that you require, the research that you require for other public interest cases. It would be an honor and a pleasure to provide you our pro bono services for this very purpose. Thank you very much all for being here and providing us the opportunity to host you once again.
Thank you so much, sir. I wanted to just take a minute and just also give credit to Emily here and the efforts of the International Bar Association. So last year, International Bar Association launched what was called a climate registry, inviting bar associations and regulators from around the world to contribute. And it was the first time that I had heard of this concept of climate conscious lawyering. And Emily has been in touch with me as well as bar associations in other parts of the country. And when I saw that for Pakistan, there was no submission made by any bar association. So that is what kind of triggered this point that, well, the Islamabad High Court Bar could, have a role to play. And we could, contribute to this climate registry as well. And it was last year through the cabinet at the time that we had the climate change committee and we created TORs for that. Last year we were engaged with many organizations, including SDPI. I remember meeting Dr. Waleed and Ubaid last year, and they were very generous with the idea of sharing resources with the lawyers. It was also at that time that I bothered Justice Jawad Hassan on how he could support and kind of get the lawyers together, because the lawyers in the High Court Bar does have a very important role to play. And so this all began with the International Bar Association and specifically with Emily. But before I invite Emily, I wanted Justice Jawad to actually say a few words on this.
Good morning. This is Mashir Alam, the distinguished guest. Emily, I just wanted to say prelude or a virtue to what we have to do today. The reason we are all here is when, as Sarah mentioned, that this is Pakistan, as you know, is known internationally for two good things they've done. Both are the caption of our seminar today when we met at STPI. Pakistan is the first country to give judgments on climate mitigation and climate adaptation, which are cited. Then Pakistan is also known first time in the world as the first country again on giving a judgment on mandatory mediation. So both are the part and parcel of what we are going to say today. Well, spent on 35 years with STPI, we are now speaking to the Islamabad lawyers, which is because this is Pakistan is again in the forefront of having good jurisprudence by judges of our all courts giving various judgments, which we'll speak about later, how the judicial anthology of Pakistan jurisprudence has an impact abroad, and how the legal anthropology of our laws, how Pakistan is represented internationally on global climate change, COPs, all the support of STPI. STPI I'm the oldest of all of you. 35 years we've been working with STPI. STPI is a policy institute. STPI is international events. Even if in all the COPs, STPI lead, COP 29, we were there, COP 28, with the first two judges, this is Shah and myself, who spoke internationally first time at COP. Last COP in Baku, we were few judges, and good news are in COP 30 in Brazil, there'll be a huge whole events on judiciary because they're involving the judiciary now. The only reason I want to say in the beginning to take you 2 minutes is when the world were talking about environment in 1972, first time in Stockholm, they never include judiciary. They had the UN, UNEP was formed. When they met in Rio 1992, they never talked about environment. But the good news was in 1992, the entire world was led by their presidents, prime ministers, queens, kings, dictators, all were leading Pakistan led G77 with the elder Bush. 2002, the world realized 40 years we wasted because judiciary was not a part. We have to bring judiciary with us. And that is the time the entire jurisprudence of the world has been brought up, and we need NGOs like STPI to support the cause of Pakistan. The only thing before the minister comes is today, after 40 years of the Supreme Court judgment of Shaila Zia Wabda, PLD 94, Supreme Court 693, when we were representing Pakistan every month, people used to say, do you have a right to environment in your constitution? I said, no, we don't have a right. But Shaila Zia Wabda has interpreted Article 9 as right to life means right to a healthy environment. But you will be very lucky today. I must tell you now, this 26th Amendment has brought Pakistan into a new map of the world. We have right to a healthy environment, Article 9A. Every citizen shall have a right to environment sustainability and a sustainable environment. This is the word used now in our constitution. For that, I end and I'll ask Emily to tell something about IBA. We want to collaborate with you. We are doing just lots of cases, unlike the judge cases brought up in the Europe and America called copycat cases against climate change. We are a country with the suo motu power we had. We have lots of judgments now, and our judiciary is very much active. Once I've shared some papers on the group we have, Sarah will give you. Almost every court is contributing towards a good judgments. And to end the note, the Supreme Court of Pakistan in the last 2 years alone has 17 judgments on climate justice, climate finance, climate mitigation, climate adaptation. We had a very big conference in June last year where we had to tell the whole world that Pakistan in the last 2 years only had so many judgments from Supreme Court. And not because they all started when we had nothing in the constitution. Supreme Court just gave one thing, right to life means right to a healthy environment. And we are so lucky today that Justice Bashir Alam of the senior puisne judge Supreme Court of Pakistan is sitting with us, will share something with you. So Emily, one thing, like you can see on Saturday, on a weekend, everybody under one roof is here. And you can see the whole hall is full today. That shows my youngsters, the generation has a lot of commitment for environment. Thank you.
Thank you so much, sir. I'd like to now invite Emily Morrison from the IBA she's actually going to speak about the road to COP30 and how lawyers can participate in the global climate agenda. Emily?
Very much. Is everyone able to hear me okay?
Yes.
Excellent. Good morning. And yes, it is early here, but I'm deeply honoured to have the opportunity to speak with you today about how legal professionals can engage with the global climate agenda in the lead up to COP30. So thank you very much to the Sustainable Development Policy Institute and the Islamabad High Court Bar Association for lending me some of your time this morning. It's great to hear that the hall is full as well. My name's Emily Morrison, and I'm a project lawyer at the IBA's Legal Policy and Research Unit. And before I joined the IBA, I worked in commercial practice in the environment and climate and sustainability teams of a number of law firms across Australia. For those of you who might not be familiar with the IBA, we're the world's leading organisation of international legal practitioners, bar associations, law firms, and also law societies. It was established back in 1947, and its principal aims include protecting and enhancing the rule of law and promoting information sharing among members around laws, practices, and professional responsibility around the globe. Today, the IBA's membership includes about 80,000 individual lawyers, around 300 law firms, and almost 200 bar associations and law societies, spanning about 170 different jurisdictions. My role at the International Bar Association is really around supporting committees and working with bar associations to advance initiatives that raise awareness among the legal profession of the importance of climate change and sustainability issues to legal practice. The intersections between the legal profession and climate change are multidimensional, and I think everyone in the room today is well aware of those, and I know that some of those will be explored throughout today's conference. For example, climate change may have implications for lawyers' professional competence obligations, their duties of care, and there are many ethical justifications for incorporating climate considerations into legal advice. In my view, really, understanding evolving climate change risks and the national and international laws and policies that respond to those risks is really just about empowering lawyers to provide holistic and thorough advice to their clients. And this is something that will only become more important as the impacts of climate change intensify. The IBA has been actively engaged with respect to the role of the legal profession in responding to climate change for over a decade now, beginning with the Task Force report on achieving justice and human rights in an era of climate disruption in 2014. And this was followed by a model statute for proceedings challenging government failures to act on climate change. 5 years ago, the IBA published a climate crisis statement, and that statement urges lawyers acting in accordance with their professional conduct rules and the rule of law to consider taking a climate-conscious approach to problems encountered in daily legal practice, advising clients of the potential risks, the liabilities, and the reputational damage that can arise from activities that negatively contribute to climate change, encouraging our corporate clients to disclose the risks that climate poses to that corporation's entire business operations and their value chains, to their regulators, investors, and stakeholders, and also to engage in climate dispute resolution. Last year, as Sarah kindly mentioned, the IBA launched the IBA Climate Registry to provide a platform for bars to share the actions that they're taking to address climate change, whether that's at an operational level or through their engagement with members. So far, that registry has received contributions from bar associations and law societies from jurisdictions spanning Europe, Asia, North and South America and beyond. And I'm very grateful to Sarah for her assistance in contributing the initiatives of the Islamabad High Court Bar Association to that registry. I really encourage everyone in the room to take a look at that. Earlier this year, my team convened a roundtable where we brought together almost 50 bar associations and law society representatives to discuss the challenges, the opportunities, and the good practices from their experiences of developing climate initiatives in their jurisdictions. And it was excellent to have valuable contributions from a number of Pakistan's bar associations and the Pakistan Bar Council at those discussions. What was really clear from that roundtable we held is that there is strong momentum among bar associations across the globe to act on climate change through a variety of initiatives, whether that's through developing legal education programs and guidance documents to better equip their lawyers to navigate the complexities of climate change in legal advice, whether that's engaging in policy advocacy and law reform processes, as has already been discussed this morning, whether that's through measuring and reducing organisations' own operational climate impacts, or whether that's through supporting member law firms in implementing sustainable business practices. In 2021, the IBA was admitted as an observer organisation to the UNFCCC process. And since then, we've convened many events at UNFCCC conferences in collaboration with other bar associations, law firms, and civil society, that really aim to raise the importance of understanding climate change risks and how these intersect with legal practice. And of course, COP30 will be no exception. And I was very glad to hear from Justice Hassan that the judiciary will have a strong presence at COP30. I think that's absolutely critical. This brings me to spend just a couple of moments on how legal professionals can engage with the global climate agenda as we look ahead to COP30 in Brazil. The outcomes of UNFCCC conferences are critical not only for the impact that they have on the direct obligations of negotiating country governments, but also for the signals that they give to civil society organisations, businesses, investors, and of course their lawyers about global climate action priorities going forward. A couple of years ago at COP28, parties agreed the first global stocktake, which was that milestone first assessment of progress toward achieving the goals of the Paris Agreement. That assessment did find that we're well off track to meeting the 1.5 degree temperature goal of the Paris Agreement, but it also encouraged parties to take a number of actions at a global level. These included tripling global renewable energy capacity and doubling the annual rate of energy efficiency improvements by 2030 and transitioning away from fossil fuels in energy systems. Lawyers are playing a critical role in translating those signals into actions for their clients going forward. Recently at COP29 in Baku, parties agreed a new collective goal on climate finance and finalised rules on carbon markets under Article 6 of the Paris Agreement. Lawyers are critical to supporting the development of the legal frameworks for high-integrity international carbon markets that meet the requirements of the Paris Agreement rules. And lawyers are also critical for operationalising climate finance transactions and identifying opportunities for their clients in this space. Looking now to COP30 later this year, parties to the Paris Agreement are expected to submit their new nationally determined contributions, or NDCs, this year. And the COP30 president has highlighted the delivery of ambitious and 1.5 degree aligned NDCs as a priority for COP30. These new NDCs will essentially provide economy-wide roadmaps for each country's action on climate through to 2035. As lawyers, we play a critical role in turning those NDCs into action, whether that's through advising governments on legal implementation of NDC targets, or whether that's helping business and civil society clients to understand the risks and the opportunities that are signalled by those new NDCs. We can also expect to see an increased focus at COP30 on climate adaptation, which is critical, respect for science, expanding the contributions of Indigenous peoples and of local communities in climate leadership, and integrating the climate, biodiversity, desertification, and sustainable development agendas. And I see this increasing focus on integration of legal regimes as a particular challenge and opportunity for us as legal professionals. It's calling for us to expand our knowledge of the links between climate change and other pressing issues, such as nature loss, and the legal frameworks that govern them, and to consider how these may translate into legal risks and opportunities for our clients. In closing now, the COP30 presidency recently outlined Brazil's vision for COP30, and in those comments highlighted that those who refuse to reflect mid to long-term thinking, future-oriented policies and engagement may succumb to reputational, transitional, legal and physical climate-related risks. I really see a critical role for lawyers in fostering that long-term and future-oriented approach. And this is just another reason why I think it's important for lawyers from all practice areas to engage with the UNFCCC legal regime. I'll end there in the interest of time, but thank you again for the opportunity to speak today, and I wish you all the best for today's dialogue. Back to you, Sarah.
Thank you so much, Emily. And I know you said you had to leave, but it would be great if you can stay a bit longer and listen to the rest of the event. So we are actually joined by Ms. Rumina Khurshid Alam from the Ministry of Climate Change. She's the coordinator to the Prime Minister. Ms. Romina, thank you so much for coming on short notice. So we're here to talk about climate conscious lawyering and mediation. So it would be wonderful if you could, speak, because we have members of the bar present.
Let me add something to her.
Yeah.
She was the coordinator to Prime Minister, acting like a minister for the climate change, and she led Pakistan successfully at Baku. Totally on her own, and Buland can very well vouch.
In my humble opinion, Honorable Minister is like the godmother of climate change in Pakistan.
Ms. Romina, if you just want to say a few words just for opening, that would be wonderful. Thank you.
Well, thank you very much.
Islamabad,
जी जी पढ़ा था Bismillahirrahmanirrahim. Assalamu alaikum, and still the morning. Honorable, my lord, I'm just half an hour late because my driver was not available and no driver was willing to bring me over here. But anyways, once again, very good morning and assalamu alaikum to all of you, all the people who are sitting over here. Of course, for me, it's a great honor. And I'm really, really touched and humbled by your kind words, which you have said for me. When it comes to climate change, of course, not only the climate change, I think everything which is the need or necessity for living, it is the right for every human being to have. Either when we talk about the SDGs, of course, previously in the last comment in the PDM time as well, I was being the convener for the SDGs task force of the parliament. And that time also, it's not, I will not say that it's me, of course, it's all the team. In fact, I'm really grateful to that delegation which came to, of course, Justice Mansoor Ali Shah Saab, Justice Jawad Saab, Madam Justice Aisha Saiba, that the efforts we wanted to have over there, Alhamdulillah, I believe it's a huge success that the things which we have mentioned over there, we, those alarming situations which we raise over there, we got a success on those things. Getting back to these subjects, when we talk about Pakistan, of course, who knows better than the people who are sitting over here, and who knows better than Justice Jawad himself about the climate change, the issues, the challenges which we are facing. Because for me, of course, when we talk about the mitigation and adaptation, of course, in Pakistan, internationally, the huge pressure on Pakistan is to, go for the mitigation side and look forward. But of course, the biggest challenge for Pakistan is adaptation, of course, because we have very limited resources in which we have to, work and cope up. But getting back to that, that is, of course, not the solution. Of course, we have to raise the voice. But on this note, I really want to, because in this 11 months of time, I'm still the coordinator, but I strongly believe in these time, in those specifically those months, the biggest challenge which I feel that we need to have the climate courts, those courts which have to take a quick action, because this is something more, of course, same like any murder, any criminal act. Of course, those people who are doing any sort of a climate negligence, they are doing the criminal offenses. Other than that, of course, the high-rise buildings, the mechanism, the monitoring system of the buildings, of the areas, of everything, like if we talk about the water system, of course, that is also biggest challenge, not only in Islamabad, of course, in all Pakistan, that how the water is getting, mixed because of the people who are earning the money, but they're just thinking for themselves, not thinking for others. So these are, of course, these are the very major challenges. But other than that, I think today we are blessed enough that we have in our constitution as well now about when we talk about the climate. But we all know that Pakistan is a highly legislative country. And still we are bringing more laws, of course, but I think now it's more over the time. And of course, I would really like to thank the Supreme Court as well. In the last few months, we have seen, in the last era, in fact, we have seen that lots of judgments came, lots of pressure came, and of course things need to be done, because when some law is there, the implementation has to be seen. But I think the right thing for the right people and to get them done is the most important thing, because now of course, as we talk about the we all know that when people talk, we all talk that the next wars are going to be on water. God forbid, I don't say that any war should happen. But of course, when we talk about young children, I think we all who are sitting over here in this room, we all have got an opportunity to live our childhood in a way. But my children, our children, my grandchildren, your like nephews or nieces, they're not getting that support and time that they can't even play. So there are so many challenges, but more than that, I think the watch to properly watch and to build up the mechanism, it's very important. But I believe strongly that all the lawyers who are sitting, and specifically I would like to request, as we are working already, and I really want to appreciate the role of SDPI for that COP in which we talk about the judiciary system and the of course, because I strongly believe that in the climate, of course, in all the things, but when we talk specifically about the climate change, as we all are the state's pillar, like even it's come to the parliament and the judiciary institutions. But the more important thing, again and again, I say that we need to have an international caucus on climate justice, because alone we cannot fight our case. We need to come up for the regional solutions. We need to come up with the lobby. We need to come up with that way that where the people should sit, and we can put the pressure on the International Court of Justice, where that should come up that these people, like all the human beings, have the right to live. It's their right, and those who are the people who are the reason of that concerns. Of course, this is not the way that somewhere someone has said, like we all like if we talk about the Paris Agreement, of course, we all know that so many things has been decided in that. So this is something human right issue, a biggest challenge. So how one can move on from that, and how those countries who are responsible, how they can walk away. So these are the things, of course, I would like to learn and hear more, and looking forward, and of course, in the guidance, whatever we can, because of course I'm sitting over here among a very learned people who are this side and another side, and of course online as well. So whatever I can do in my humble capacity, along with the support, I would definitely love to do that. But because it's not only that I have to do, of course, every individual matters a lot. And again, I would like to request that I strongly believe that we need to have the climate courts for sure, and to come up with a quick mechanism of those cases to be sorted out, because these are the challenges. Sometimes if we raise a voice, somewhere the ban comes, but the other people from that side, they come up with the stay, and that stay, like that, those all efforts which we put, they just go in a vain in a few seconds. So how that mechanism can be watched, and how we can go more towards the solution, that's I wanted to say. And in the end, I always say, and today again, I would like to say that that it's not me, it's not you. It's not a matter for it's not a matter for anyone else. It's for us. So when we together work, so of course, I just stay alone. But when we become us, so then it makes more strength. Thank you very much.
Thank you so much, ma'am. I think you've really summed it up well, and actually pointed towards a lot of issues that should give us lawyers something to think about, and how lawyers actually have a very important role to play when it comes to climate change. I'm going to now move towards actually our first panel, which is on the role of climate conscious lawyering, mediation, and education in creating a climate resilient Pakistan. And for our panelists, if I can have Dr. Palvisha Ayaz Khan, who's the executive member of the Islamabad High Court Bar Association. She's going to be a speaker. Mr. Secretary, if you can actually switch seats with her, that would be wonderful. So she can join our next panelist, Mr. Umar Sumru. And then I would also like to invite Mr. Muzaffar Mirza. He's the Commissioner Law at SECP. Sir, if you could actually come this way and join us on the panel.
I'm a commissioner licensing and licensing and registry.
I would also like to introduce Syed Buland Hussain. did I get your last name wrong? Sohail, sorry. He's the head of programs and partnership at IBA at ADR IC, and he's actually been very much involved with organizing this event as well. So he's also going to be speaking and sharing the mic with me if you don't mind. No, it's fine. Mr. Muzaffar, I'm actually going to start with you. So when we talk about climate conscious lawyering, the concept is that climate change is no longer just for environmental lawyers. So if there are young lawyers who think, well, I'm not really into human rights or I'm not into environmental law, so climate change has nothing to do with me. The idea is that climate change is impacting every practice area. So it is a duty upon us as lawyers when we are representing our clients to also think about how climate change is going to impact our clients and advise. And so it starts with educating ourselves. That's why we want to promote climate literacy within the lawyers, because if you educate yourself on the subject, only then can you advise your clients in the best way possible. One of the changes that are happening in Pakistan are in the regulatory space. And so I see SECP really playing a very important role in shaping the corporate sector's approach towards climate resilience. I've come across some guidelines as well. So, sir, if you can first give an introduction about yourself and what is it that you do at SECP, and if you can lay out for our audience the guidelines or the legal frameworks that have been introduced by SECP with regards to climate change or sustainability.
Thank you. Thank you very much. I'm Muzaffar Mirza. I'm newly appointed commissioner. I'm not the commissioner law right now. I'm commissioner licensing and registration, which means, but I've been associated with SECP for the last 14 years. I was a head of legal and chief prosecutor. What we SECP as a lawyer, I'm not probably here to speak on behalf of the lawyers right now, but yes, for future, I think we have moved from CSR, which is corporate social responsibility, to ESG now, which if you see the two words changing, the social part remaining the same is the environment and the governance, and that's a very important change as how we see sustainable growth in the and especially in the law. The companies, as per the regulations you just mentioned in 2024, is more tilted towards a disclosure at this time. You know, when you talk about governance, environment is as Adam informed us that environment and governance are interlinked now. How the corporates, how we conduct ourselves is very important for the environment. It is the most important is as citizen of this country and as citizen of this world. We have now responsibility and duty, the corporate sector especially, to govern itself in a manner which is sustainable and environment friendly. And when we talk about environment and sustainability and governance, I see a lot of women here. We ensure also that women are also part of that governance thing. It's just not environment. Our focus is, yes, environment and also equal opportunity. You will happy to know that SECP around at this time around it is 30% of our workforce or our is around our women. And we are probably the only organization in the government level that we wish to take it to a level where women are 40% of our workforce, and we're employing and we're ensuring that women are part of everyday workforce and they bring a change. So it's important for lawyers because in future. Right now, the guidelines are basically is around is not mandatory, but probably the focus is disclosure based, is how they are conducting themselves, and then in future that this can be we would like that companies to ensure that the public disclosures are mandatory, they are appropriate, they are correct. So I think we're moving in a way where we're ensuring that the environment, the corporate sector especially, and I'm here to represent the corporate sector, is tuned to make a better Pakistan and a better world and more responsible. So this is the basic approach. I hope this is all I know right now. I've just joined.
Sir, you mentioned about the ESG guidelines and how they're voluntary and not mandatory. Would you be able to get into a bit more detail on just maybe examples of what these guidelines entail in terms
For
of
example,
disclosure?
Disclosure, they have to ensure that, how much water they're consuming, what effect their industry or their company or whatever their business is affecting on the climate. So that's a mandatory disclosure. And then what is the policy to mitigate that impact on the environment? So that's a part of they have to have a special sustainable report also. And when they file financials with us, there's a cost that the climate is incurring, and what they're doing to mitigate that is also reflected in the financials of the company that they filed. So this is a disclosure base, but it is very important for us to, and this is how we can monitor their progress for now.
Yes, and I guess then that's where lawyers would step in terms
Definitely,
of, ensuring
definitely,
compliance,
definitely,
even though it's voluntary right now.
Right now, yes, but you can know the impact, and then,
Yeah, I would encourage everyone, especially I see some law students here, to check out the ESG guidelines. I think they're not very complicated, very sort of, simply put out and very easy to understand. And, again, in the future, because it might become mandatory. So, I think important for us all to be familiar with it.
let's say, don't scare the corporate sector with the mandatory. I think
No,
for
no.
now,
No, it's-
we like we actually, and
But
this
you're
is
promoting.
for now.
Yeah.
It is not only it is now applicable to the listed companies,
Yeah.
but we also encourage the non-listed companies also. And you know the difference between listed companies who are listed in the stock exchange, or public companies are basically supposed to comply, whereas the other companies, we are encouraged to do so.
Thank you so much, sir. I wanted to now invite Mr. Umar Sumro, actually. If you could, because Ms. Rumina, ma'am, she talked about climate change disputes as well. So we want to link in mediation into this space. And just to begin with, if you have any sort of opening remarks on the topic, and then I'll move on to the questions.
Sure, thank you. First, I'll just say my customary thank you to Justice Jawad Hassan, who's been a driving force here. I'm representing Sindh in many ways. And in that respect, I think it's very kind of him to invite me up here so I can give the perspective of Karachi and Sindh generally. And much of what Ms. Rumina said earlier that touches upon construction matters. I'm glad that Justice Mushir Alam is here, whose family home is in an old part of Karachi, which was surrounded by the most beautiful homes. And now he's surrounded by a concrete jungle of illegal construction, where perhaps his home is one of the few that is standing as a bastion of what was old Karachi. That touches on environmental laws. And I wish to address some of those gaps for our lawyers here, since I've been a General Secretary of the Sindh High Court Bar on 2 occasions. Justice Mushir Alam, welcome here, sir. In fact, I should be welcomed here by you since I'm visiting your city, sir. Justice Sufyan Rana and Justice Ghazan, Emily, who's here with us in spirit, and Bulant, who's been such a quiet force behind all of this for so many years. And Dr. Qayyum, thank you for welcoming me here on behalf of the STPI. And of course, my brothers and sisters from the Islamabad Bar Council and the Islamabad High Court Bar. It is always lovely to be here with our black coats. I just want to shed some light, and I've divided my address, which I want to limit in just a few minutes, in 5 parts. First is the legislative gaps insofar as Sindh and Karachi is concerned. Now, I drew up a table and I looked that in Islamabad, there is proper legislation for the mediation. But in Sindh, as opposed to Punjab and Khyber Pakhtunkhwa and Balochistan. We don't have legislation as such. We have an amendment in our civil procedure code. There's a section 89A which encourages mediation. Now, when I was a younger practitioner, when Justice Mushir Alam was a senior puisne judge, there was a push towards mediation. It was a good initial push, but then it faded away into oblivion. And we need to address that with minor tweaks in the legislation. We need to have in Sindh a mediation act in order to enforce mediation. Now, members of the Islamabad High Court Bar have the same concerns as members of the Sindh High Court Bar. What does that mean for us as lawyers? Now, in the Commonwealth, particularly in the Indian subcontinent, we want to know, is this an attack on our advocacy? Is this an attack on our ability to represent clients and earn fees for our legal professional? And that needs to be addressed too. The second thing I want to address is the present data. It took me 4 days to obtain data from Sindh on the success of mediation. And the only persons forthcoming were the members of the judiciary who immediately through the registrar shared the data. But the other accredited associations in Karachi are hiding and are cagey about the data. They're not sharing it with the lawyers. They're not sharing it with the general public. And there's a right to information. Why is this relevant for us as lawyers? Lawyers from Islamabad going to Karachi for their clients on a mediation matter. We don't know, we can't advise our clients what the success of mediation is. I just want to throw in a few figures of what's happening in mediation in Sindh, which is virtually nothing. But in Karachi, which is the only city in the province of Sindh which has mediation centers. So we need to expand. The third thing I want to do is just a brief comment on the data. Why? Because what are the nature of cases coming for mediation? We as lawyers, as black coats, need to know when we advise a client. Sorry, Emily, I'll go into the vernacular here. कि हमें अपने client को हम क्यों बोलें कि mediation में जाओ? हमें तो फीस हाई कोर्ट की मिल रही है या डिस्ट्रिक्ट कोर्ट की मिल रही है. Why should we go towards mediation? What does that mean for us in the security of our profession? If the data is not being shared by the mediation centers, why should I tell my client to go to mediation? It's a very simple truth, but there has to be some enforcement. The fourth thing I'd like to say is that there are provincial inconsistencies in the law. Whereas in Sindh, in theory, the law is better. The courts, the judge in a high court has complete discretion, or in the district court has complete discretion to send the matter to mediation. In Punjab and the other provinces in Islamabad, it is with the consent of the parties. But yet in Sindh, the judges are reluctant to send lawyers ke bhai sahab mediation mein chale jaye na, yahan itna shor kyun ho raha hai? Why are they not doing that? Because there's a gap in the data. I want to address two loopholes in the legislation, and I think Ms. Rumina touched upon something that's very close to my heart, and that is the building violations in Karachi. They touch upon lawyering everywhere in Pakistan. Karachi is a haphazard city, but it is the life and blood of commerce. And the push for high rises and building colonies is so great that around about the time when Justice Mushir Alam was Chief Justice of Sindh High Court, a lawyer was assassinated in his chamber. And where he lives now is a 20-story high-rise. He had obtained an injunction against the builders. His mother is now migrated to her only daughter in Bombay. So that is the problem that lawyers are also facing. So let me just start first on the bar and the bench. Now, I said in the beginning that we are not being able, although our law is better in Sindh, we're not being able to encourage lawyers, and the judges are not encouraging lawyers to go into mediation. Part of the reason is that we don't have the data to advise our clients that, you're going to pay us a legal and professional fee for going into mediation. It's going to be at a mediation center. the fee would be the same. We need to tweak the legislation. In Punjab and Islamabad, the good thing that has been done is that an appeal from a mediation has a very limited scope of success. Just like an appeal from an arbitration, unless the arbitration award is so illegal and perverse, an appeal is limited. So in the same way in Sindh, we need to ensure that if we advise our clients to go into mediation, an appeal from that is a constitutional and a legal right. But the appeal from that should be limited so we don't re-agitate the entire issue that took place in mediation, because the driving force of mediation for us is to make Pakistan investment friendly, to improve our rankings, both for national investors and international investment. We need to close the gap. So the legal fees we earn would be directly proportional to the finality of what is happening in mediation. Sorry, Emily, I'll go into the vernacular again. अगर हम अपने client को कहते हैं कि mediation है, air condition कमरे में होगी, सूट टाई पहनेंगे, 2 हफ्ते में complete हो जाएगी, उसके बाद दूसरी फीस मिलेगी. The client will say, sorry, we don't want to go into mediation and pay you twice. What we need to do is, whatever award is settled or the settlement is arrived at in mediation attains a certain finality. The judges must have the power to impose costs on a party that refuses to go to mediation unreasonably. The other thing we need to do, in Punjab, they've done successfully. In Sindh, we just have a letter from a registrar saying, oh, well, in these matters, family matters, commercial disputes, please go to mediation. Under the divorce laws, you're supposed to go to mediation anyway. So there's no driving force. So we need to have a schedule in our laws, just like in Punjab and Islamabad, that in all these matters, it is up to the discretion of the judge to send the parties to mediation, impose costs on the party, not the lawyer, impose cost on the party that refuses to go to mediation, and any appeal from the mediation should be of a very limited scope. So we have closure. Now let me share some data with you. I thank Mr. Justice Adnan Chaudhary of the Sindh High Court. He was the person who was forthcoming with the data. The other institutes that the ADR institutions have recognized were not sharing their data with the lawyers. And the court-appointed mediation is not so attractive for lawyers because the mediator is free. And that directly hits upon the lawyer's fees. So the privately appointed air-conditioned rooms of people are not so open to us. And we need to tell them that this is the area of the black coats. You must inform the black coats because it is the black coats that are advising the public whether to go to mediation or not. And we will charge our fee which is commensurate with the mediation and what is at stake in mediation. So for instance, if you are charging 500,000 rupees for a district court case, you would charge the same in mediation. And the benefit to the lawyer is that the mediation closes in 2 weeks, whereas in the district court, he'll be with that 500,000 rupee fee, walking in the district court for the next 3 years. So there's finality, there's certainty. Now, in the cases referred to in mediation by the High Court, of the 258 cases that were referred, my friends, 92 or 35% were successful. Unsuccessful were 15%. Returned at the very initial stage were 120. Why were they returned? We don't know. We need data. Our lawyers need data. They are the engines and the driving force that will assist the bench. Because the bench and bar, we always say, are the same two wheels of the cart. But if they are not moving in tandem, one wheel will be, the bar will be putting the brakes on. No, hold on. We don't know what's happening. We don't know if it's in the interest of our client. And we don't know if our legal and professional fees will be secure in this method. It might hit at our profession. Pending cases are about 2.7%. Now, this is the interesting part, why we need a schedule. We need a schedule in Sindh of all the cases that must be referred to mediation. Mandatory. Otherwise, costs will be imposed. Only labor appeals went. Now, labor cases ordinarily don't drag on for too long anyway. It's really a question of the collective bargaining agent and the employer and the minimum wage. What about our suits for specific performance? our family disputes and all the rest of it. So the Masala International Center some cases, they have total of only 7 cases in mediation since August of 2025. Only 23, sorry. And successful were 2, unsuccessful were 3, pending are 2. So these are very poor reflections. I'll now come to the subject of, I'll just close now. Building laws and environmental laws. The building laws are the key for lawyering in Sindh at least. And I can see now with Islamabad growing, also for our lawyers here. Illegal constructions coming up. What Ms. Rumina touched upon. The building laws need a minor amendment to include mediation before you go to the Sindh Building Control Authority. Because at least with respect to Sindh, the Sindh Building Control Authority does not inspire any confidence, which is why Justice Mushir Alam's home, which has on residential leases, is now surrounded by high rises, which are all on commercial leases. So when the public or a resident goes to the Sindh Building Control Authority, the building regulator is never found. Mr. Director General is somewhere else, but he's not in his office for obvious reasons. The push is too great of the builders. We need to have mediation so lawyers can mediate. They charge the same fee. Who comes in the mediation? The DG has to come. Who orders it? A judge like Justice Jawad Hassan orders the mediation. If he doesn't turn up, costs are imposed. He loses his job or is suspended. The other thing, environment. High rises have a direct impact on our climate. Where there is one pipeline for a residential home, if 6,000 residents come there, it has a direct impact on municipal functions, pollution. Do you know that in Karachi, 2 million gallons of untreated waste is dumped into the sea? That is what is happening to our fishermen. Across Sindh, that is what is happening to the Indus, in Sakhar and other big cities. You are dumping your sewage into the sea. There is scope for lawyers there to obtain not just injunctions, as Ms. Rumina said, an injunction comes and the whole project stops. Investors don't want to come to modernize the country, right? We need to have mediation. An environmental protection order should be driven by some mediation brought in by lawyers. So I'll just conclude there as food for thought that these 2 laws need to include mandatory mediation. Our lawyers need to be given the protection and the certainty that when they're going to appear, the stakes will be as high for the client. Because the order they will obtain for their client in mediation will have some value. It cannot be overturned by simply a stay order in the High Court. No, it has to have some finality and the scope of appeal should be limited. Thank you.
Thank you. We're going to have actually questions right after the panel, so I'll come to you, Siva. Bulant, I wanted to bring you in because Mr. Umar Samro talked about, the scope of mediation, and you talked about the challenges actually. So just to, move the conversation along, do you then see potential of mediation being used to resolve climate change disputes? And if you can shed more light on that.
Thank you so much. Umar Saab, thank you. You kept alive the memory of a very dear friend, Mohammad Mursa Chinoy. He gave his life, we believe, fighting the building mafia. So one example of a very brave individual and a dear friend of ours. Thank you, sir. Thank you, Sarah. Thank you, Madam Minister, Honorable Justices, dear and I would say also very brave visiting justices from England, leaving the heavy docket of work to contribute to Pakistan. So big round of applause for them, please. I'll shed light on mediation first, and then I'll take this, my brothers and sisters. By the way, it is such a privilege for me to be here in the same room as you. For the past 3 years, I've been in dozens of conferences on climate. But it's the first time Justice Jawad and I have the privilege to be before our brothers and sisters of our profession. Islamabad. Yeah. So thank you so much for coming. And thank you
Hello.
No. Thank you for coming, Ji, Jaja Saab and the Honorable Executive Committee. Thank you so much. Mediation pe I'll shed some light because that was what Umar Sumru Saab discussed. I think what I've taken all the points that he's mentioned, they were spot on, absolutely spot on. Now, mediation pe, Umar Saab, I'm going to respond to you. Some very good news. Firstly, very grateful for the honorable judges to about making mediation the center point of legal practice. Judicial first, and then now legal practice. So I have some very good news. I'm coming from Lahore. In fact, we are coming from Lahore. Our visiting judges were part of a very high-level training, mediation training that we did in conjunction with the Lahore High Court Bar Association. Yesterday I wasn't there, but Judge Sufyan sent me videos and pictures. Packed hall, what, 300 people? Packed hall, presided by a very senior Lord of the Islamabad High Court, the Lahore High Court. I was very, very well received, and I believe the Lahore High Court Bar wants to work with us to establish a mediation center in conjunction with other centers as well as the Lahore Chamber of Commerce. Before that, we did an event in January with the Malaysian Bar Council, with the Sindh High Court Bar Association. And the Sindh High Court Bar Association has already passed a resolution to establish on the court premises a mediation center in collaboration with IBA and in collaboration with the Malaysian Bar Council. Inshallah, sir, Islamabad High Court has taken the lead in this area. As you know, they've established the Court Annex Center, and now they've taken over the center and the ownership of this movement going forward. Monday ko we have a event thanks to Justice Jawad Hassan and Talha. I don't know if he's here. Yes, Talia Alyas Sheikh. A very, very large event, Rawalpindi High Court Bar Association, presided by 6 honorable justices of the bar, and is going to be a jam-packed affair, I hear. This is Monday at 11 o'clock. And I believe on the agenda is also the passing of resolution to establish a mediation center, again driven by the honorable bar. जी CCP पे वो event है, but mediation पे नहीं है, वो competition laws पे है. Then Justice Jawad is taking the initiative again of doing a similar exercise at the Peshawar High Court Bar with the blessings of the Peshawar High Court. So I think Umar Saab, we're on the way. President Metlo ke saath, I think you and I need to have a meeting. Inshallah, we'll do that next week. Now, when it comes to environmental mediation, I just want to say that we're in the middle of extremely delicate situation, not only internationally regarding the water, but domestically as well. So anticipating this, I just want to announce, it's a bit premature, but in May, we're having a webinar with the leading environmental international mediation provider, which focuses on post-conflict resolution and environmental dispute. It's called Mediators Beyond Borders International. Madam, they're a member of the UNFCCC. Balki I met them in Baku. And the case studies that we will be developing for those trainings will be all Pakistan-related water disputes, international and domestic. That's our agreement with them. Ma'am, if you can join the webinar, that'll be great. Our request is to include all the provincial and federal climate desks, climate departments, environmental departments, as well as ISRA and the water bodies. Let's give them live examples and let's take them out of the talk shows and into the mediation training so they can resolve their disputes and also get international accreditation in the process. So with this, very quickly, climate pe dekhein, I'm a student of climate, but I realize a lot of people in this room have very basic understanding. So I'm just going to touch upon what it is all about. It's very simple. It's what carbon you bring into the world on a daily basis. Once you know what carbon your footprint is, for example, you came here in a car, that's a carbon footprint. And you will go back somewhere, that's a carbon footprint. So you need to understand how much carbon you bring into the world. Once you understand that, then you know how to take it out of the world. So that's called mitigation. This starts at the individual level, at the association level, at the bar, as well as at the corporate level and the government level. These are called NDCs, nationally determined contributions. Our NDCs, which is a very detailed exercise, but the concept is simple. This is how much carbon the country brings into the world. And this is our strategy to take it out. So our unconditional NDCs that we've committed to the UN is about 300 million metric tons, which we have to remove if we have to stay in the game and insist on our right to receive compensation as the most affected country in the world. We are the 5th most now. So the ministry and the federal government and the provincial governments need all the support from all the multi-dimensional groups, actors, stakeholders to achieve this target. This story doesn't end here. About 700 million metric tons is unconditional target because we emit close to a trillion, billion, which is we're still under 1%, by the way, globally. So this is a huge societal effort, and PAR being an important stakeholder in Pakistan needs to understand this, and then, of course, take its place among the other leading stakeholders of the nation. Muzaffar Mirza Saab, I'm so grateful he's here representing the corporate sector's regulator. I believe there are 2 regulators in Pakistan which are critical to helping the cause. One is the State Bank and the other is SECP. Now, SECP ने जो इतनी बड़ी interesting बात की, CSR to ESG. CSR is corporate social responsibility. Pakistan, as you know, thankfully is one of the top 3 giving nations in the world. Take any index. Pakistan Center of Philanthropy, Islamabad-based body, unki reports nikal lein. We are the top 3 most giving nations in the world. Now, what we're doing it with SECP, we're making a plan to improve the engagement with the Ministry of Climate Change, firstly. But the basis of that engagement is how do we pivot these billions of rupees going into CSR, which is a blind sinkhole, black sinkhole, unmeasured, ad hoc, undocumented, and pivot that into ESG, ESG framework. And again, ESG framework kya hai? How much carbon a industry brings into the world, and then understanding how do we take it out. And thankfully, our federal government has led the way. We have developed the world-class carbon activity rules, which basically is a Paris Treaty UN-driven document, which means that any carbon credits we generate from Pakistan will automatically land into compliance markets in Europe, Japan, Korea, Switzerland, and Canada. And this will give us an immense opportunity to earn a lot of foreign exchange for Pakistan. So big round of applause for the ministry. To be honest, they've done spectacular work. Acha ji, I'm going to speak very fast now because my time is running short. Article 9A of the Constitution, extremely important. This relates directly to us, our practices. We are custodians of fundamental rights. Article 9A unambiguously, again, a initiative of the federal government, gives everybody a right to clean, healthy environment. We are custodians of the fundamental rights alongside their lordships. So this is a practice area for you, even without applying your mind too much. You are responsible for fundamental rights. This is one area where you need to make your inroads as to enforce these rights. Secondly, the laws in Pakistan, we have cutting edge climate laws now. Cutting edge, from the Climate Change Act to the National Adaptation Plan, climate change policy, rules, regulations. Islamabad ka bhi act hai, abhi jo announced hua hai. Islamabad Wildlife Board hai, and the disputes are in front of you. Islamabad Wildlife Board, again an issue. आप देख लें अगर कोई भी newspaper उठा लें, at least 4 to 5 headlines relate to climate and law and climate, the intersection. So it's a no-brainer for me. Ever since I've started my practice in climate and my clients have known that I'm now in climate, I am now advising on climate issues on almost a daily basis. So I would urge you to get involved. We will help you get involved, and I will explain to you how also at the end of my little speech. Why are you relevant? How are you relevant? I think that's the question all of us is asking in the room. Firstly, Article 9A. Secondly, interpretation of laws, application of laws, advisory on the laws. Thirdly, it is your ethical duty as an officer of the court to make sure that the laws of Pakistan are faithfully applied. Your constituents, which is your clients, are aware of that, and you have to help and guide them reach their objectives and also the national objective. अभी जो इंडस्ट्री में आप देखेंगे with SECP's regulation, State Bank has come up with the green taxonomy, which basically means all the sectors in Pakistan they've identified and streamlined. These sectors will now be investing in green projects from EV to agri-waste to urban waste and you name it, to building codes. So the regulators are making policy for finance to flow in. Ministry of Climate Change is making policy for new capital to flow in this area. And of course, where capital flows, that's where lawyers become relevant. Engagement with stakeholders. This is the primary classic example of how lawyers can do good work, reforms around climate as well as mediation. Sit in the room with legislators, executives. Ma'am has been a member of parliament also. So sit in the room with judges, sit in the room with executives, sit in a room with regulators, and come up with ideas and promote reforms. So that's another way that you can contribute. And this is also intellectual activism. इस राउंड टेबल के बाद प्लीज गेट इन्वॉल्व विद अस द बार वी शुड डू अ व्हाइट पेपर एंड विद SDPI and wrap up this beautiful gathering. That's your intellectual input. So the bar, I would say, has to take charge. I am so happy that the Islamabad High Court bar, being a leading bar anyway on all reform-based, intellectual-based efforts, is now getting involved in this extremely vital area of the law. So coming just last points, how we can help you on both mediation and climate, at least my organization, which is my own firm first and then IBA. I'm running IBA's Mediation Center. IBA board has also given me the mandate to establish their Climate Finance Center. Now, thanks again to Ms. Romina. We have an MOU with the Cambridge University. We signed it in Baku. We're bringing 150 top quality climate courses to Pakistan on a free basis. Each cost of this course is £2,000. 50 of these courses is going to go to the federal government to distribute amongst their best minds. 50 is designated for judges and lawyers. 50 is designated for civil society. Inshallah, the next few weeks we will make a list, and I think it'll be very representative. My only request is that if you're selected for this process, Cambridge University's only one request: please finish the course. There's no exam, there's no assessment, but you got to finish, sign on at the right time, the right day, and finish it. Give them the courtesy of giving this opportunity to Pakistan and sharing the best knowledge in the world with you. Second thing, very, very pleased to announce Justice Jawad's brilliant breakthrough with the other leading university of the world, Durham University. Durham is coming to Pakistan in October, pre-COP. We will design a beautiful conference with them. Again, pre-COP, climate finance based, legal based. They're sending 5 of the leading professors in law, climate, and business to Pakistan. And they want a 7-day event here with all the stakeholders. So Justice Jawad and I are going to be working on that. Lawyers will be involved. The third is as you said, Emily joined the International Bar Association. Emily has invited us to Milan in May 21st, 22nd. I'll be going, and I believe some of the bar leaders are joining us. This is on sustainability and climate change. And IBA, International Bar Association, would really love to be involved with the bar leaders. They've offered a significant discount. Tara is very well aware of that. And the invitation is open. Once you get involved globally, believe me, you will be get a chance to go to COP. COP में आपका mind खुल जाएगा, and you will connect yourself just by being there with the rest of the world doing cutting edge work on climate. So let's also discuss that. Thank you so much, Sarah, for this opportunity. Thank you for all the hard work.
Thank you, Buland. I think you've given some great advice and tips, particularly to the young lawyers. I would like to bring in Dr. Palvisha Ayaz, who's the executive member of the Islamabad High Court Bar. And if you can kind of give your perspective on the concept of climate change and mediation, where do you see climate change disputes, and can ADR or mediation play a role in resolving those disputes?
Thank you so much, Sarah, and good grace be upon all the members of the panel. May they be comprising the lady, and as well as the justices, as well as Emily, who's online talking to us. It's the greatest pleasure is to be representing the bar at this point in time. We have some excellent grey cells sitting across the panel who have given their most graced judgmental talk. It's not judgmental, but it's the insight into various aspects of the present scenario that we are going in. I won't go into the depth of it because each panelist has spoken very well. And I'll just add on as not as a moderator, not as a student of a university who has worked on the climate change. I'm a student of King's College. I did my PhD from there, and then I did my second PhD from Al-Azhar University. So I had the chance to be on a very diverse level, in the sense that coming from an Oriental schooling in Al-Azhar, the climate impact of my country, representing Pakistan on a forum where I didn't have the assistance of all you gentlemen to be able to guide and to assist. But being a moderator, mediator, it's only when I came to Pakistan and I came as a landlord's daughter coming to my lands and seeing the effect of climate change. You see, you've got to understand when you are on the front level and you're personally affected, that's when you get to understand. The gentleman, Mr. Sumro, spoke of Karachi. I have such excellent memories because my father, working in the armed forces, served across the length and breadth of Pakistan, from Cholistan Desert to the Siachen base camp. So I can see the diversity of the problems or see the crux of the problems affecting us. KP is badly managed. I'm sorry to say the Indus water flowing down from the mountains and the gorge where it comes in conjunction, the pollution, the effect of the plating of the climate floor is badly scarce. It's so bad that honest to God, I feel that you're talking about sustainable development, it's at its lowest ebb. The KP government, the KP policies, well, you are very much ingrained in the constitution, but please let me just take away the veneer and explain it to you that there is no conjunction and there's no conjoined plan of action. Everything is on the paper, but nothing do we see actually being embarked upon. Mr. Bulan, you have worked very well. I'm very much in picture what each gentleman has been doing. Why? Because I'm assisting my university on that work, and I'm working on the KP Board of Climate Sustainable Action. And I can vouch for one thing, is that your laws, your Supreme Court is very well formulated how it's working. But we have no coherence between the High Court bar and the bar of the KP government. Where I come from, I would like each one of you to come. Please, it'll be an honor for me. Just 40 minutes down the line, you come and see. And I can take you to the dams. I can take you to the areas where you just see how much it's affected. You're talking about the COP30, what's coming up. Mind you, it has got a lot of lacunas in it. They need to be addressed. They need to be addressed on a very pragmatic and minute level. I won't take your time. I won't take you to the pragmatism, but as far as mediation is concerned, mediation only comes to effect where you put something on board which is actually working, which is actually has an interaction with your moving conjoined policies. It's not working. Please forgive me for saying that the entire bar, it's such an honor for the entire bar to be present here. This is the first time we are seeing activism. But our mediation, where is it working? It's not working. Please forgive me for saying it. Ma'am, I'm not giving a very myopic sort of a viewpoint. But with due respect, ma'am, I just want to bring it in picture for you that there's a loose thread somewhere which needs to be realigned. Forgive me, ma'am, you need to go into the places where, like, I'm not talking by the book. I'm not talking, I hail from a place, I'm a farmer's daughter. And I really, this is the first time when I got into the true picture of it, and I realized that the scarcity of water, the pollution, the carbon emissions, you see your lawyers go back into the same old homes. But like Buland rightly said, please, we need you all to be able to assist. But ma'am, there's no plan of action. How will you sustain something which is just on board or just on paper? So with due respect, I feel that as a mediator on the national level and on the international level and the senior executive member, I would request that we have an insightful gathering once again, where we can bring on the lacunas of what the law is at the moment finding, and then we can move on. So anything that I can feel right now, everything is rated very well as spoken, but as a international climate activist, I would like to put in this thing for whenever you all have a question coming up. Thank you so much.
Thank you, Palvisha. Thank you so much. Sure.
Thank you very much, Madam Palvisha. It's a great honor for me listening such a beautiful and thoughtful and painful as well, heart to heart, because most of the people, like few of them, Justice Jawad and of course there other people who are here, because I know action speaks more louder. And when it comes to law, of course, there are the evidences for every case. When some case been, in front of the court and of course in front of the Lord and all, the evidence means a lot. So at the time of the COP and other way around, in these all times so far, I don't think so that in media as well and here as well, anybody can say that I'm talking about myself. Taking the responsibility of the climate change, I have said something which is not willing to work with each other. At the time of the COP, of course, we all know that there are so many political differences and so many issues which are being done. But other than that, at the pavilion of the COP, that was not Rumina's pavilion. That was Pakistan's pavilion. And the KPK government and the people, when they came, I tried my level best that the world, because of course, when we talk about the carbon markets, when we talk about the plans, KPK have lots of potential. As you have mentioned about the plating and all that things, I went by myself. And I would really like to say, it's nothing to highlight myself. I never said that I'm a learned person. I never said that I'm an expert, because my job is not to be an expert. My job is to learn and to see and to get the most from the people who are expert, and then to sit down along with them and to see what is more best and better for the people of my country, and then to bring it on the policy paper. And because, of course, I strongly believe that I, as a parliamentarian, my job is because I'm from the people, by the people, and because of the people. So in that way, I've tried many times, and somehow in few things we got a success. But of course, unfortunately, as I've said earlier, कि पाकिस्तान होगा तो कुछ होगा ना. अगर हम अपनी अपनी जेबों में, अपनी अपनी उन कूजों में बंद रहेंगे, तो चीजें नहीं sort out होंगी. And that is, for that matter, honestly, it's nothing to highlight. मेरे पास तो वैसे अल्फाज नहीं है जो उन्होंने मुझे कहा, लेकिन I just wanted to say that by all means, every time, चाहे मुझे जाना भी पड़े, मैंने तो जब भी कोई issues इस तरह के हुए, I've said that I'm ready to go and see the all leadership over there, that how we can work. Because again and again, there are so many times, either at the times of either it's flooding, it is a cutting, deforestation, anything. Because of course we need to work. And for the climate change, I always say that the climate has no borders. No visa, no ticket. It's going to be just, it is already there. We are already too late. It's a state of emergency for all of us, that and I'm really grateful to all the lawyers and of course, all the laws who are sitting over here, that it's something very, very important, and we need intervention of every second person, everyone, but in their own capacities. अब देखिए बहुत सारे laws मौजूद हैं. मैं सिर्फ quickly time थोड़ा सा लेना चाहूंगी. Laws मौजूद हैं, लेकिन अब जो हाई राइज बिल्डिंग्स बन रही हैं, जैसे सिवरेज की बात की, वो बहुत सारी जगहों पे इश्यूज हो रहे हैं, चाहे वो मनाल हो, चाहे वो कहीं और हो, रावल डैम हो, समुंदर हो. So, we let it be done. I still remember I was a child and I learned from my grandfather that I was 7 years old, and I remember that the Japan was working on the recycling of a water. So as we talk about the SCCP and others, of course, they need to have the mystery shoppers who can go and watch and see. Because at the time, you have very rightly said, because the things are on the paper and then it went. And still, I believe the more criminal things are happening in the climate change. But still, I would request, because lots of learned people from the law and justice are sitting over here, that to bring more diversity and knowledge. I'm so glad that IB is doing great things, that internationally, climate laws are very much important. The courts and the education for the lawyers is very much important, and I think next coming up the world is very much there, and and anything if I can do, I'm very much there to work. Thank you. My pleasure.
आप इनको इनवाइट करेंगे ये जरूर आएंगे
नहीं, invite me, आप मुझे phone भी करेंगे, I have no issues.
Thank you so much. I thought it'd be a great opportunity to take a couple of questions. We'll start with in the front row.
Working closely with the pioneers of the mediation movement last year, very actively, and then before that as well. I would say let's not forget the facts first and foremost. Pakistan contributes very little to carbon emissions. This is not the problem that we created. And let's also keep in mind two things: mediation, climate conscious lawyering. The judiciary has really driven the mediation movement last year. So much has been done. And when such judgments come, they're for the entire nation. And we can't say that we have not. We've spoken about climate justice way back in 1994 in the Sheila Zia case when nobody else spoke about it. Again, we don't contribute to the carbon emissions still back then. And then there has been a string of judgments where mediation is concerned. We've had some big cases such as Morga Valley, Faisal Zafar, where 42-year-long disputes have been resolved through mediation. The Taisi case, there is so much, this entire room. This is proof that this movement is being driven, and it's so closely tied into climate conscious lawyering. Both are going hand in hand, and both the bar and the bench are making a very, very strong contribution in that. So I wouldn't say for a minute that we should think that in Pakistan we're doing any less. We're doing more than is required even. Coming now to the question that I had for Mr. Sumro. I feel that like in the last 2-3 years, we've seen a lot of strong judgments, and the judgments have primarily been driving this mediation movement, giving it strength, like you said, court-backed mandatory mediation. And we've seen most of them come from Punjab, whereas one that comes to my mind, Justice Yusuf Said and Ghulam Asghar Pathan case. So what is the reason that you feel that not so many court-backed mandatory mediation judgments are coming from Sindh, whereas Sindh is the commercial hub, and we saw one judge take the lead. But if there are any more, I'd be very happy to hear about them, sir.
Thank you. I think it's a very pertinent question. I think the simple answer to that question is that whereas in the other provinces, there is a statute that governs and pushes and encourages advocates and courts to send matters to mediation. In Sindh, it's a mere amendment of the Civil Procedure Code, Section 89A, that has been amended. And that 89A is also limited in its scope. It doesn't even include arbitration. So what I am proposing to our lawmakers, and we have one on our panel, that the federal government should perhaps push the Sindh government to also enact the same law that the Islamabad Capital Territory has enacted. That's all we need. And that should give confidence to the black courts, and also give statutory backing to the bench that if you don't go to mediation, we will impose costs, because if your client's refusal to go to mediation is unreasonable in the discretion and the mind of the judge, then there will be costs. That complemented with the fact or coupled with the fact that if you go to mediation, आप सिर्फ मीडिएशन में इसलिए नहीं जा रहे कि आपको एक एक्स्ट्रा फीस मिलेगी. Your legal and professional fees would be the same as if you were going to agitate this in a district court or the high court. Why? Because the statute is saying that if in the discretion of the judge go to mediation for a quick dispensation of this, and the settlement arrived at will have a very limited scope of a successful appeal in the high court, then the lawyers take it seriously because the client has to take it seriously. Why? Because the stakes are as high as if you were appearing before Justice Jawad Hassan in the high court. So the fees is not affected. The finality is there. So that's all we need. We need the same law as you have in Islamabad and Sindh.
So, Dad, I'm glad I've seen you after. Please come on Monday to see the positivity. As I just in 2 minutes say, the English judges are here. We don't use the word we use now is mandatory mediation. When I was sitting as an English judge in England 2 years ago, I was sitting with Robert Justice Suker, the Lady Chief Justice, and Geoffrey Vaux. They overturned the judgment of Hesley, 2002 England and Wales Court of Appeal, page 771, by the new judgment called Churchill, 2023 England Wales, the judgment which says this mediation is mandatory for a party to do. Then England did that, and we gave the first judgment in Pakistan, which I gave, that is Faisal Zafar 2024 CLD page 1, then picked up by Borga Valley, picked up by Supreme Court. Finally, the Supreme Court of Pakistan has now given a detailed judgment 2025, PLD 25 Supreme Court page 1, the Mughal construction judgment, where paragraph 6, footnote 7, Justice Shah has elaborated that there's good efforts by the entire Pakistan, because after that I gave a judgment on mandatory mediation. I explained, I was so happy, not my province. Immediately, Justice Shahid Kareem followed a right. Justice Yusuf Said in the 24th Karachi, Justice Adnan Chaudhary, Junaid Khafar, the acting Chief Justice, the entire Sindh High Court, not referred, not followed, relied. We are judges. We are Pakistanis. I'm addressing to lawyers of Islamabad High Court. You should know one thing. When you don't have a law, Article 189 says the judgment of Supreme Court or and Article 201 says a judgment of a High Court, decide the question of law, shall be binding on all the courts below. So why we go out every year, I'm starting a course at LSE now, that Pakistan is the second country in the world after this, like the English courts, after the judgment, they changed the law. And the law was changed of the civil procedure, which Sufyan will say. Pakistan is another country in the world after the Strategic Planning Division judgment of PLD 24 Lahore 565, which I gave against the then the government amended first time in the world in the income tax law, section 135 says there will be a mandatory mediation for any amount of the SOE. So when we say, and we travel all the world, people give us red carpet. Oh, you are the second country in the world after England who got the judgment and the law was changed. You got the judgment, law was changed, not by one. Justice Shah's judgment, 2023 SCMR 1856 RVK, 2024 SCMR 947 Haroon Construction, 2025 Lahore Supreme Court page 1. Then you talk about the artery, clocking the artery of arbitration, 2023 SCMR 156. These are the Supreme Court judgment binding on us. And Islamabad has done good work. They've done good work on the mediation center. But Punjab, Shahid Karim Saab, Abid Aziz Saab, 5 judges. And what we say, judiciary is united. And these people we feel very proud to say, oh my God, one judge started this thing. The entire judges, because the biggest joy for a judge is not to be followed, not to be referred, is relying is Stretio Descendi article 1. Because relying is that I'm relying on my Lord's approach, not binding on me, strong principles, the concept of reliance. That's why they came to Pakistan, these 2 judges. Oh my God, we want to understand what you're doing. They've been coming to Pakistan. They had one very good week. But I want to invite all of you please come there are 6 judges sitting together in the and Lahore High Court Rawalpindi bench, 20 minutes away from you. 10:30, the program will start. Allah will give you details. The entire judges are sitting only on one cause. That Pindi bench started 2020, Faisal Zafar, 2024, CLD, page 1, where indirectly we use the word that mediation is mandatory by the judges, not sending the matter. Every week hearing it, what happened now? And that's through the case management plan. And another new concept we've given is early neutral party valuation. I've seen the file. I know both of you. Why don't you settle? I can see the law because I can evaluate your case through an evaluation. It's a very successful model. I'll give you all the booklets. अभी पढ़े भी हैं और तल्ला साहब इनको दे देना. All judgment, there are 15 judgments now in the last 1 year. Supreme Court, Lahore High Court, and Sindh High Court, Peshawar, and the best thing is PLD 2025, AJK High Court page 1. PLD 2025, CLD page 225, Justice Shahid Bahar, even relied on the approach. वो आपको मिल जाएगा. I'll book. अभी इनको booklet दे देना. I send you a booklet.
Yes, please. Thank you, Julie.
As well. So, okay, sure.
It's incumbent upon the parliamentarian and the legislature like to make it so to fix the legislative loopholes. That is very important. Number 2, it's incumbent and the legislators are mandated to get it enforced or implemented, whatever the legislation can be now. They will consequences. Unless we put cost or in consequences, we cannot redress these violations. And so far as mediation is concerned, I would endorse Justice Jawad's statement that try to make it mandatory. Otherwise, it is useless.
Thank you.
As you've mentioned about the loopholes for the parliament, as you said, the parliamentarians and the Pakistan, we have huge parliamentarians and the laws. As you know, the strength and the unitedness today, we have seen the uniformity because after the 18th Amendment, we all know that every province, they are independent. So that is as you go through my title. So my title is that I'm the coordinator of the Prime Minister on climate change and coordination, environmental coordination. So this is something which is lacking, which Madam Palvusha has mentioned right now, that the KP side, how we can. So this is something which we are trying our level best, because unless, like suppose some judgment has been or some laws or some legislative work has been done in Islamabad or done in Punjab, so rest of the other provinces, of course AJK and GB as well, because for me next my greatest threat of my own is the GB, that how we can save the environment, because now most of the tourists are coming towards GB, the mountaineers and all. So what sort of things we can do? So for that, I think the most important thing is the provinces, how much serious they are to take, the steps move forward. So I think this is something we are working already on it. But of course, and I'm so glad that Justice Jawad and along with his team and all the Pakistan bars, and of course they're today here, and that is something, because जब हम इकट्ठे हो जाएंगे तो पता मिल ही जाएगी.
All right. We'll take, okay, you can go, Hassan, and then pass the mic to him. Thanks.
Thank you very much. My name is Syed Hassan Ali Raza. I'm an advocate of the Supreme Court of Pakistan. I'll make one very concerning comment, literally beg all of you by touching your feet and then sit down on that concerning note. Islamabad and Rawalpindi comprises of 2.4 million people. The single source of water for Islamabad is Khanpur Dam. It has 80,000 acre-feet of water. It belongs to WAPDA. Since 2005 till 2025, the water has deteriorated by 2,600%. The 3 reasons for that are: number 1, motorboating. Grease is being thrown into it. Number 2, the amount of garbage by hotels and resorts. Number three, around three sides of this, there are now societies which are leaving sewerage into it. Number four, the single source of water of Khanpur Dam is Nilan Kas. Nilan Kas is a tributary in which there is stone crushing blasting going on, so that is blocked, and so that all the sediment is thrown into it. I was engaged by WAPDA. I went to the federal government, didn't get any help. I went to the provincial government, didn't get any help. I went to the environmental tribunal, didn't get any help. I ran from pillar and post as a lawyer. Do you know where I got help from? The library of Mr. Justice Shahid Karim and the library of Mr. Justice Jawad Hassan. I have filed constitutional petition number 69 of 2024 under Article 9A, which is pending before the Supreme Court of Pakistan. 5 months, I have not got a hearing as yet. I would request you as federal government, I would request you as members of the Islamabad Bar, I would request anybody from the civil society, kindly join that petition. Kindly, the water that you are drinking, it is in front of you, it is filtered, not treated. You are, the water that's coming from there is.
File the contempt on the very strict judgment to 2013 Sumutu case of pollution in Rawal Lake, 2013 SCMR page 591 and 2013 SCMR page 594. कोई बच्चा भी खोल ले फोन पे लॉ साइट पे 2000 SCMR page 591 or 594. There the Supreme Court then gave a detailed guideline and made it writ of that said is continuous mandamus. If you put that two judgments, you'll see because it deals with the entire Rawal Lake, half in Punjab, half in Islamabad.
Absolutely.
What to do.
Lordship, with your Lordship's guidance, that very part and that very judgment is in the petition. We've asked for reinforcement of that. Of course, we got it from the library. But the idea is to actually tell you that the water you're drinking is not even worth bathing from. Be it in the parliament, be it in the judiciary, be it in the Supreme Court, be it in front of you. Have a sip of it. You're happy drinking filtered water. Trust me, it's not treated water. So on that note, I will ask for your help. I will ask for your help. Please join this proceeding because this is the water this is the only kind of water that we have. Thank you so much.
If I may, can I just put in a word? Honorable Judge, just give me I have a question for you. That if a particular judgment is part of the petition, what recourse do you have? What recourse do you have to air your views on a more judgmental, on a more concise, and a more authoritative manner?
The judgment is a part of the plaint.
Yes, the plaint.
And you want this judge to follow that?
Yes, and
But-
you have, like this gentleman just rightly said,
So
that to
that
air your
will be-
views, what exactly do you pertain to? How do you?
That will be if a judgment of a Supreme Court is in the plaint and the ratio descendi of that case, not opera dicta, not state decisis, if the ratio descendi is applicable to your case, it's binding because the word used, it enunciates the principle of law. If a High Court judgment is in the plaint and you want it to be binding on the judge, then you follow that and then you follow the concept of 19th PLD 1960 West Pakistan 9253, which I reiterated in Hamza Shahbaz Sharif taking the oath as the Chief Minister of Punjab, PLD 2023 Lahore 546. They were that if a judgment is in the body and if it decides the question of law, if a strong value of other courts, though not binding, the court may follow that. That's something you have to understand. Read the book of S.M. Zafar called Law of Precedents, the concept of sovereignty of the judgments, and you have to read it carefully with the opera dicta, state decisis, and this should descend as something very, very important. A, B, B, C,
Yes,
C.
Haji.
That is very important. Thank you.
Thank you.
So yeah, just last question, and I promise there'll be another opportunity for questions when we
Madam?
move on to the second panel. Yeah.
My name is Ali Imran. I have done LLB from Karachi University. My question is that air quality index, which is falling a lot because especially due to industrial areas are approaching residential areas. So I have a lot of cases where the residents have sicknesses lungs problem issues. It's rising because of population rising, and industries are being constructed a lot in industrial zones. As in Islamabad, we can see this industrial areas inside the city, not outside. So how, Sir Umar, I will ask from Sir Umar that what help citizens can get from legal professional judiciary to especially make laws that protect their citizens. Thank you.
Question, because I didn't have that much time to go into detail, I have recommended certain amendments in the Sindh Environment Protection Authority statute. These amendments touch upon mandatory mediation, which was also observed by Justice Jawad Hassan here. Mandatory mediation before the agency, which is the Environment Protection Agency, passes any order. So practically speaking, as you rightly observed, my learned friend, that if you want to complain about the poor air quality index, we hear about a lot of it from Lahore sitting in Karachi, but Karachi is also getting worse. As you rightly observed, the industrial areas are mushrooming into residential areas, right? Then you have diesel public transport that is also contributing to that. Now, the way the law is made, the SEPA Act, the Sindh Environment Protection Authority Act, you file as a lawyer or a citizen, a resident, you file a complaint before SEPA. That agency then responds. It sets up a complaint redressal system. That can take many months. Having observed the law and read it before coming to this meeting, I have proposed that a mandatory mediation take place before an environment protection order is obtained. So a resident like you in Islamabad or Karachi for that matter complains to the agency. The agency is then bound to entertain that complaint in 7 days to 2 weeks, binds the site association, the industrial association, and the industry itself that is causing the pollution, that may be part of your complaint. To resolve this, whatever award or settlement comes or failure arises from that is then taken to the agency. So the agency already has an accelerated system of saying, okay, well, this is what Mr. Khoker identified. The Environment Protection Agency is now going to be cognizant of that. We will not start from zero. A settlement failed. These were the mediators. And now we're going to continue from this point onwards. So we need to bring in mediation there. Once again, you will need expert mediators. We will now encourage the bench and the bar to train its judges in the district courts and its advocates in the districts and the high courts to become trained mediators. So they are also advocates and they are also mediators. They can perform both roles, but in mediation, they will be identifying the problem. The difference is that as advocates, we are adversarial parties between plaintiff and defendant. In mediation, we are identifying only issues. Bhai, tum pollution kar rahe ho. Arey bhai, main nahi kar raha hu pollution. Arey bhai, kar rahe ho. Okay, so let's identify the air quality index. Let's identify that site association, which is the trading body association in Karachi, is dumping 1 million gallons of untreated chemical waste into the sea. So that is an issue. So rather than being accusatory, you are giving data. Then the Environment Protection Authority is saying, okay, well, who's responsible for this? In Karachi, it will emerge that the government is responsible. So the mayor of Karachi is called and a budget is allocated and then milestones are kept. So you are not accusing the shoemaker, the tannery. The tannery is not defending itself against you. Oh, you might shut us down. This advocate is so good. We're binding the government. 2 अरब रुपए हैं, पूरे साइड में 6 treatment plants बनाइए और 2 साल में बनाइए. So that's what we want to do. Lawyers earn fees, environment becomes better, and mediation takes the same role as adverse litigation is taking. So SEPA ke kawaneen, the Environment Protection Authority Act must contain mandatory mediation, as Justice Jawad Hassan has said.
जो जजमेंट्स जितनी भी हैं वो जैसा आपने भेज दी हैं, तो मैं कोशिश करूंगा कि बार काउंसिल के बार एसोसिएशन के पेजेस के ऊपर वो अपलोड कर दूं ताकि सारे वो देख.
जजमेंट दी है, आर्टिकल जितने लिखे गए पाकिस्तान की तारीफ में, सारा कुछ अभी आपके बैठे बैठे इनको दिए, इनको भेजे, तो सर दवाई साहब कहाँ है?
बैठे
मुझे मिल गई। आप जरा अपने सारे ग्रुप में बांट दें, तो 6-7 चीजें ताकि उनको मैंने मिल जाएगा कि सारा पिंडी बेंच पे
Thank you so much. So with that, I'd like to conclude the first panel and thank you to Mr. Omar Sumro, Mr. Muzaffar Mirza, Dr. Palvisha, and Ms. Romina as well. You gave some very, I mean, I appreciate the fact that you responded to every question. So added to the discussion in the panel. We'll move on to the a second panel, which is going to be on domestic and international judicial perspective on environmental justice. We'll take a minute to reset. In the meantime, we have like a brief announcement. I'll give the mic to Talha to make an announcement.
Assalamu alaikum, ladies and gentlemen. As Buland Saab has mentioned and Justice Jawad Hassan has mentioned that we are having an international symposium on mediation and ADR in general on Monday, 28th April 2025. Registration starts at 10. I invite you all to join us there. It's going to be a great symposium. Justice retired Mashir Alam is our guest of honor. We will be joined by Judge Sufyan Rana and Judge Ghazan Mahmood as well. So last year, what we did was we had a first seminar for the awareness. And this time around, what we will be doing is that we will be bringing the skill sets to the members of the bar. Universities are joining us there as well. And it's going to, and we are hoping that hopefully we will sign a resolution for the creation of our own court annexed mediation center. So looking forward to join you there, and it was a great event today. Thank you all.
Thank you so much, Talha, for that. We would like to begin our second panel. For the next 30 minutes, we're going to be talking about domestic and international judicial perspective. Again, we are talking about environmental justice, but we're going to bring in climate change and mediation, but from a judicial perspective. So I'd like to introduce our three panelists, starting with Justice Jawad Hassan. So judge of the Lahore High Court, we all know him very well. So he also sits as a shadow judge in the English courts, and he also teaches at various in international universities. And he's known for his work specifically on climate finance as well as ADR. So we're going to get into climate finance with him. We also have Judge Sufyan Rana, who's a district judge based in Manchester, UK, and is visiting Pakistan. Thank you so much, sir, for joining. We have Judge Ghazan Mahmood, who's a barrister and a deputy district judge in England and Wales, and he has about over 25 years of experience in various areas. So thank you so much to our panelists. Justice Jawad Hassan, I'll start with you. Wanted to kind of introduce or allow you to introduce the topic of climate finance for our audience, and if you can set the scene and what's the scope of it in Pakistan.
Bismillah Rahman Rahim. The time I took while answering something, so I'll take out the time.
Yes, thank you.
Because everything is time bound and time specific. I must share a good news for Pakistan that in this, as I said, we and some judges, we travel internationally because the Western world recognizes Pakistan's judiciary and its impact, a new concept it has given. And the two most important fields since Shalazia and judgments is the climate and the mediation, which is now has become the trend. And it's very difficult to be recognized and to be accepted and to be referred and to be relied on by the foreign and the Far East countries, which Pakistan is very much lucky to have now. Dil ki baat karunga, 2 minutes samjhaunga why are we here. I'm very happy that youngsters are here. You are future generation for Pakistan. I'm glad I'm addressing this to you now. I must say one thing. 100 years ago, they were referring the word negligence, Ryland versus Fletcher. 80 years ago, the word changed, the thing was the same, this is climate change. They used the word nuisance. 70 years ago, they used the word tort. Then 60 years ago, they used the word trespassing. And we've been reading common law, English common law, same word, environment, air and water. When the world started talking about environment in 1972, we got carried away. What environment is? Pakistan got the law of 83. But then the whole world shifted. And the word which came in the world is climate. I must say something to you. I went to the law school in America and doing my LLM environmental law. When I was taught climate change and climate justice, 1995, I thought, what a joke. Is it something exists? And I was taught not by somebody, I was taught by Robert Kennedy Jr., now the Secretary of the State Department, the Secretary of Health of US. Robert Kennedy Jr., Bob Kennedy. He was my professor at Pace University. And he was telling us about the world will change in climate. And 95, हमने कहा कुछ क्या होता है climate? ऐसी चीज तो कोई नहीं है. What it impacts the whole world. They talk about El Nino effect, greenhouse gas effect, the different words coming to climate now. When coming back to Pakistan, we got involved in work and all with the sports of UN and all. Pakistan is becoming prominent. And then 20 years ago, word climate justice, then climate protection, environmental management, ISO 14,000. I don't want to talk about anything else. I am the most vulnerable country in the world. Pakistan suffers the worst. 3 years ago, flood, 8.9 million people were flooded with the rain. Because the world is using something, Pakistan has an impact. What are you doing to me? Can I get funding from you? 1992, when the world sat down, when you travel in economic conference, you say, I'm the developing country or a developed country. But when you travel on the climate justice conference, the world divides you not for Muslim or non-Muslim. Oh, you are a global south, I'm a global north. The entire north. So the word you use is global north and global south. And the word we use here is 92 Agenda 21. The Earth Charter said, not please help out the south with some funding. We need money now. No, there was no international document binding the world to give money. COPs are non-binding. COPs are just agreements, confession of parties. That's not binding. When they brought the Paris Agreement, when they had United Nations Framework for Climate Change in 1992, when they had the Kyoto Protocol, they had the Copenhagen Protocol, they had the Paris Agreement, Global Pact for Environment. They agreed Article 9, Article 5, Article 16, that they will be funding some world for this. COP facilitated. When Pakistan was going in COP28, I must say, me and Justice Shah was the only two judges in the entire COP28 talking about law and justice. And I only chose one project. I have shared, can I be seen in, I've shared the climate finance paper, which is PLD 2024 journal mein chapaya maine, is I want to talk about climate finance. I am suffered. Can I get funding? I'm not asking for a loan. I can't pay you a loan. I'm asking for a grant for Pakistan. And the grant would be in the terms of, and fortunately, with the efforts of the ministry, we had 49 events at the pavilion in Dubai in December. And fortunately, Pakistan, Sulari Saab is the one, STPI always facilitates us. STPI has a panel there. They always takes out, hame wo last mein le gaye the. Pakistan, mashallah, came to the world map, became the member of Loss and Damage Fund. When we became the Loss and Damage Fund member, this year when we went to COP with Mr. Meena, we did a lot of good things also. Question is, do we have a legal framework in Pakistan? And I conclude with 6 words. Yes, we do. When the world says, why did you clap when we speak there? I say, excuse me, I'm the first country in the world which gave the judgment when you don't have a right to environment. The Constitution of Pakistan, Article 9, was interpreted by Shala Zia that right to life means right to environment. There was a clap in the entire audience. I'm the first country in the world where the soft law of international law became the hard law by the Supreme Court. The UN Declaration, Stockholm Conference is a soft law. Vienna Convention 1961 says there should be a hard law or a soft law. Soft law becomes a hard law when the Supreme Court enunciated that precautionary principle. The principle prevention is better than cure. there's a principle of Rio Declaration principle, soft principle, but brought to a Pakistani judgment and became a law for all of us to follow. They were collapsed again. Then I said, we are the third. I'm first time. I'm first, second time first. And my third time first is, we gave the first judgment in the world of climate justice. This is Shah's Asghar Lagari case, PLD 2018 Lahore. A first judgment coming out of the mitigation. For fifth time first, we are the first country in the world. I share that judgment with you, which I gave of climate adaptation. The pre-plantation all over Pakistan, tsunami ka concept jo tha. Again, they were collapsed. Sixth time first we in the world on the concept of right to food wastage. Food security is the threat to the world. That judgment is taught at Harvard Law School. Ahmed Pansota judgment, PLD 2020, Lahore 229. We are the first country which talks about the concept of, the basic concept of what is the concept is food security, food shortage. And all of that which I say to the world is, I don't start with I said, because my constitution of Pakistan starts with the word of Bismillah ar-Rahman ar-Rahim. It starts with the word of Allah. The sovereignty, whereas the preamble says, whereas the sovereignty of this universe belongs to Almighty Allah alone and His sacred trust. Pakistan is another good thing is how we brought the concept of Islam and sustainable development. What you now know, concept of sustainable development to meet the ends of future generation without compromising the present generation. That is the Hazur Pak Sallallahu Alaihi Wasallam's Akhri khutbah. And when he was in 632 AD, spoke to the world, listen to me, I will not be here with you in next few hours. Listen to me and dismantle to the whole world. I want to say something. The rights are the fundamental rights. When you look at the all khutbah of Hazur Pak Sallallahu Alaihi Wasallam, that's the true translation, what they have called the Petition of Rights, the concept of United Nations Declaration of Human Rights, 1948, 10th December, the United Nations Covenant on Civil and Political Rights, 1966, and the Pakistani Constitution, 1973, Article 9 to 28 are rights to life, right to movement, right to speak, right to religion. All that is given to in the khutbah of Hazur Pak Sallallahu Alaihi Wasallam, which the United Nations in 1998 on celebrating the 5th anniversary of the UN Declaration, acknowledged by the then Secretary of State, Hillary Clinton. We do agree the fundamental rights which are the UN are all the last khutbah of Muhammad, the Prophet. We are the country, our constitution is very clear. We are celebrating 2024 that we had the amendment on the 21st October 2024. That's called 26th Amendment 9A. 9A I read in, which I was very popular in COP on Amal Sukhera case. A 3-year-old girl, when Lahore was the most polluted city in the world, Lahore. And fortunately, I've been in Pindi Bench, so I was just went there 1 week. I witnessed the worst toxic pollution. 3-year-old girl, granddaughter of Senator Ali Zafar, granddaughter of Ahmed Nawaz Sukhera, came to my court and said, I am 3 years old. My school is shut. I'm with my laptop. I can't go to my garden. I can't go to my grandparents. I can't go out. This is my life. And I gave them tough time. I said, can I hear you? You're 3 years old. Because are you a person under Article 199? Are you, because the words in article of the constitutions are in the fundamental rights, a person, which you're not under Article 260? Are you an individual as per Article 10A, right to fair trial? You are not. Are you a child? If you read Article 25A of the Constitution, it says child means there's the fundamental right to a free education of a children from an age of 5 to 16. So you're not 5, you're below 5. So can I hear your case? What was the answer could be? And I must say, to make everybody be me more, I said, when I was hearing this case in the morning, and I was very excited that I thought Amaluddin Koloni came to my court. That very famous Amaluddin Koloni, not Amal, it was Amal 3 years old. When she came to my court and asked this question to them, what could be the answer? The order is reported, is published, is on a website. What could be the answer? She is not a person under Article 260. She doesn't fall under individual. She's not a citizen, because a citizen has to be under Citizenship 1951, read with Article 260, sub-Article 4. So what could she be? A 3-year-old coming to my court? Answer. No. No. I mean, you know that. Because you brought a case. No, don't be Rundi. I'm testing the Islamabad High Court's judicial anthology of judges here, lawyers. No, but read the word of Constitution. No. Can I hear a case of 3-year-old? Ramina, can a 3-year-old come to my court? How? She's not a person. She's not a child. She's not a child.
She's an entity.
No, read Article 1, the amended Article 199A, 199(1)A says that for the removal of doubt, the High Court shall not make any order beyond the articles and also sumutu. So that was the limitation of the 26th Amendment. So what is the answer? No. No, but Sanjay, can she come to my court 3 years? That's I'm asking you a question. पिंडी के वकील ऐसे जवाब देंगे आइन में बात करें आइन में बात करें आइन
Sir, isn't it right to life? She has a right.
But right, no, but can she come to the High Court in a writ petition?
Yes.
No, she can't. एक मिनट, वो फैसल मलिक कहाँ बैठा है बैंकिंग का लॉयर है? नहीं, but आप लोग बात नहीं समझ रहे. Does she have a locus standi?
Absolutely.
And is she a aggrieved person? But when you read the word of the Constitution, Article 199(1), it says subject to the Constitution, comma. And there's no fictitious remedy available, comma. No. Who said that? Wait, उससे पढ़ा हुआ है. PLD 2023 लाहौर 148 में मैंने explain किया था जब मैं बच्चों का केस admit किया था. The word says, well, Article 199 doesn't mean say. It says when there's no fictitious remedy available, any aggrieved P-A-R-T-Y party includes a foreigner, party includes a 3-year. So the word party is intertwined with all the words of Article 9 to words person, individual, citizen, or any person you want to. Thank you. Your name? Your name? Islamabad High Court? तो आपको उसने impress कर दिया मुझे आज. So anyway, thank you. So anyway, so that was done. So let's look at positive thing. Pakistan is a good country. Inshallah, things are happening now. I want to motivate all of you because are you spending time with me. And thank you, Sarah and STPI, for doing something together. I've been meaning to see you, but I had no jurisdiction to come to you.
So it's an honor to have you.
But we've been speaking everywhere. But I want to invite all of you to come to our PD bench. We'll give you first seats. Dalla sab kahan hai? Islamabad. No, thank you. Thank you and bless you.
Sir, I do have a follow-up question on climate financing. So in other countries, I've been noticing some disputes with regards to legal framework surrounding climate finance. Do you see that happening in Pakistan as well? Is that something as lawyers we need to kind of also brush up on?
We have a very best, now start writing down the legal framework of Pakistan's climate finances as one is the constitutional framework. Pakistan Constitution Article 9A read with the Schedule 4, item number, part 1, clause 3 deals with any international agreement on environment, gives us a framework to do. Then under Federal Rules of Business 1973, it says there's a Ministry of Climate Change division. Division has a mechanism. Then we have a Climate Change Act 2017. So this is the federal law. Then we have the Climate Change Impact framework through the regulators in Pakistan. SCCP functioned under the SCCP Act of 1997. read with those are 21 CLD 931. It gives them a power to regulate on the climate financing. How do you deal with climate financing with their guidelines? Then comes the other issue, which is very, very important. That issue is how the judgments have taken care of. The Pizza Hut one. Because climate financing, the other person wants whether my money is secure. So climate financing is when you give a financing to a country, which are the parameters? The constitutional, the EPAs, provincial EPS, and other framework to the SECP, which is and the State Bank. State Bank has a green guidelines. Now, State Bank guidelines, State Bank Act 1956, Banking Companies Ordinance 1962, Section 41A that they can give a direction on climate finance. So State Bank have a direction on which is called this OP that is given to the country. So now these are the answers to make secure the foreigners to bring money to Pakistan. Then money will be protected. Thank you.
Dr. Abid Suleri, if I can bring you in, because you're also the member of the COP29 International Advisory Committee. So if you can add to the topic of climate financing.
Thank you. I think all I would like to say here that while we talk of climate finance, we need to come out of our victimhood mentality first. We keep on repeating Pakistan is the top vulnerable country. We keep on repeating that we are the worst victim, which is factually correct, but it should not be the basis of our climate finance mobilization. By definition, climate finance means any finance that we are spending to increase adaptation or mitigation against climate change, which means if one start looking in Pakistan, besides public expenditure, any expense that one is making on installing solar panel, any expense that one is making for a hybrid vehicle, any expense that one is making for decarbonization, it is part of climate finance. But it's just the middle class and upper middle class. The real climate finance example from Pakistan that comes is the flood 2022. Now, after flood 2022, the need and damage assessment for the losses, how much it was? $30 billion. The need, the loss and damage in Pakistan after floods 2022. In the Geneva conference of donors, the pledges which were made were $10.2 billion. Till last month, Pakistan received 3.1 or $3.2 billion, which means the losses were $30 billion. Pledges that came were $10.2 billion. What we actually received, and that also includes the existing the loans and existing commitments from ADB and World Bank and Islamic Development Bank, it was $3.2 billion. If you go to Sindh, interior Sindh, if you go to Balochistan, and Umar Saab will vouch me out, if the life is not normal there 100%, if it is not normal there 70, 80, 60, 50%, people, they have made their own makeshift houses, they have made their own makeshift schools, they have constructed or tried to redo their roads. Now, if the loss was $30 billion and the international community gave $3.2 billion, from where rest of the money came? It was the community's own climate financing, which means someone sold their cattle, someone sold the jewelry that they were preparing for their daughters, other borrowed money from their relatives, other they used their own savings to mobilize their livelihoods, etc. So the point I'm trying to make that under this climate justice, under the just energy transition and under the climate justice rules, when we sit on the negotiation table on climate finance, we shouldn't sit as a victim, or we shouldn't sit at a begging end. We should sit there and we should tell them that, okay, this is the 15 billion, 10 billion, $5 billion that my community has spent from their own resources. And now we are talking of the matching grant. Now we are talking of the matching finances. And that, I think, if we start tagging our spendings on climate resilience, on spending on climate adaptation and mitigation. That will strengthen our case. The second very important point here that I wish that the legal fraternity they take to courts is the dichotomy right now on just energy transition. Solar panels vis-a-vis the capacity payment charges. Now, the one argument that we are provided again and again that the solar panel is something which is just for the upper middle class who can afford those solar panels. By the way, STPI doesn't have this solar panel, so I'm not saying it for my own sake. And I live in an apartment where I can't have a solar panel. So, but the point I'm trying to make that solar panel is not only for the rich and the upper middle class. Solar panel is also a huge benefit for the areas which are never provided electricity. Go to any remote village and you will find one or two plates which are actually they have innovated it on a mobile frame. They can drag it to their fields for water extraction. They can drag it to their rooftop for use in fans, etc. So we need to understand that in the interest of public, when we're talking of climate finance, when we're talking of loans that we take, whether we have to use that amount for our faulty policies by which we will keep on producing electricity from fossil fuel, or we will be able to produce the green and clean energy. And for those of you who are dealing with the corporate law practice, this clean energy would be a buzzword and would be a mandatory next year. From 1st January 2026, European Union is fully implementing its carbon border adjustment mechanism. Right now, we are talking of Trump's tariffs. From 1st January 2026, we'll be talking of EU's carbon tariff, which means that if anything that is exported to Europe, if in the supply chain, the carbon emission was higher, would be higher than the permissible limit in Europe, exporter would have to pay carbon tax. It is started from October 2023. Right now, there are 6 sectors which are covered. It is aluminum, steel, glass, fertilizer, and cement. Incidentally, none of Pakistan's export gets covered there. 1st January 2026, they are planning to expand it. Just imagine if textile is in that particular sector, what would be happen to our textile export? Right from the sewing of cotton till its export, in the supply chain, if the carbon emission is not controlled through clean and green energy, our exporter, they would have to pay carbon tax there. Imagine what would happen to the rice or the mangoes or other export that Pakistan sends. And UK is already, 2 honorable justices from UK, they are there. After Brexit, UK is already preparing CBAM. They would be announcing it by the end of this year. So our export in UK, they will also be subject to this provision. When Trump will find out about carbon tax, although he's not a believer of climate change, but he needs any excuse to add tariffs, reciprocal tariffs. So it would become part of tariffs in USA. And China is also preparing because in a tit for tat move, all of our export destination, they will be charging our exports on their carbon emission from 1st January 2026 under CBAM. And that's where the corporate sector, they have to protect their right to produce clean energy, right to produce clean and affordable energy. I think that should be a fundamental right. Why I should be compelled to pay 60 rupees per unit or 70 rupees per unit when I can produce my electricity for free? And this is where this policy priority that matters. And I submit to Honorable Justice Jawad Saab and Islamabad High Court Bar Association to take it as a public interest litigation, right to clean energy, and try saving your industry and our future generations. Thank you.
It was about just one thing, please, because it's been about the international, climate finance as well. I'm really wanted to put a light and want to bring in the knowledge of everyone who's sitting over here that at this COP29, the most important thing from the Pakistan pavilion, the voices are that we don't want aid, we want trade, and we want our right, and that's come where in the start, as I've mentioned, that I've requested to SDPI to facilitate. And of course, I've requested Justice Jawad and Justice Mansoor Ali Shah Saab, because they were being there, that to come up with an international climate justice caucus, which is very much important. Because over there, I would really like to assure you, and I wanted to bring in the knowledge of everyone who's sitting over here, that the funding is not in billion, the funding is in the trillion, but access towards that climate finance funding is impossible for the countries, developing countries, because the mechanism is too tough. Other than that, as we all talk about the loss and damage fund, which already Mr. Abid Suleri has put a light on it, there are most of the things from the developed side, they are the eyewash for the developing countries. Same at this point when we were there, I and along with another minister from the Egypt, we both ladies tried our level best to have a proper. We didn't went over there to ask any volunteer help. We were not begging them. We put our case in a right way, eye to eye, and we said that, listen, we want, because in my country, I said very clearly that, as we all know, that a 3-year-old girl who came up with this, of course, issue, and of course, it's a right. So over there also, I've mentioned that sitting over here and coming to the COP and giving so much money, because UNFCCC, when we go over there, every pavilion has to pay. And it's not a small amount. As we talk about the loss of Pakistan, $348 billion we need as a country. And over there, how much grant they were saying? They were talking about 200 something, and then we put up a case, and then it comes to 250 and then 300. And that is amount which is, God knows better after how many years going to be, we're going to receive. So that was something we have mentioned. And I really want to, again, thanks to the judiciary, that on the Pakistan's pavilion, the lead, Justice Jawad and Justice Mansoor Ali Shah Saab and Justice Aisha was also there. The way they have taken, we hosted international judges over there, and they were all talking about this, because this is something we need to come up, that this is the right of the vulnerable countries. Because of course, everyone is, because we have, as Mr. Abid Suleri have mentioned about the negotiations, in those negotiations, we said, like, these developing countries, for one thing, we are bearing the consequences, which we are not responsible. And then all the allegations on us. And unfortunately, in Pakistan, because of course I'm going to talk about my country, that the important thing has been always been covered by the urgent. So urgent matters come first, and the important things left behind. So this is something which we are trying our level best, and we are looking forward for the more support. Thank you.
Thank you so much. Sir Sufyan, I'm going to come to you. I thought let's pivot the conversation back to mediation. I think you've heard about the challenges of mediation in Pakistan, and you've also had an opportunity to, visit Lahore, and you've come to Islamabad. So if you can maybe start by giving your perspective from like the UK's perspective on why mediation works over there. Maybe we can, apply some of those concepts in Pakistan and take the conversation forward.
Thank you very much. Can everybody hear me, first of all?
Yes.
Thank you. Bismillahirrahmanirrahim. Quite a passionate debate that I've heard this morning, and about two subjects that are very close to my heart as well: issue of climate change and mediation. First of all, I'm very grateful to you, Sarah, you, Bulent, wherever he is, SDPI, and of course the Islamabad High Court Bar Association, for giving us the opportunity of addressing you today. I intend to be brief, not least because I can sense the passion in the room, and you probably have a lot more to say than probably want to listen. As you know, I'm a judge of England and Wales, not United Kingdom, small but important distinction. I mentor, recruit, appraise and train judges in England and Wales. I sit on a subcommittee of the Online Procedural Committee that's looking to devise rules for a prospective digital justice system that will ensure cases start and end digitally with the assistance of ADR and AI. That said, I have a very strong Pakistani heritage, which is the reason why I'm here. I'm keen on acting as a bridge between the English judiciary and the Pakistani judiciary because not only are we part of the same fraternity, but we face the same resource-based challenges. In England and Wales, I'm part of an international training group which seeks to establish connections with judges in other countries. We have an international judicial unique mentoring program, which I'm hopeful Pakistan judiciary will actively engage in, because I think that will be mutually beneficial to both of us. I'm very grateful to Mr. Justice Jawad Hassan, of course, for the very active part he plays generally, but the particularly active part that he has played as a bridge between Pakistan and England. Now, turning to the topic at hand, I have a master's in ADR and mediation, and I'm also writing a book on mediation. I'm about 85% through it, but if you've ever been a writer, that's as close to 0%. Despite having been a litigation barrister for the majority of my working life, and now as a judge who makes decisions every day of his working week, I'm unashamedly a litigation pacifist. Now, whilst the courtroom has traditionally been used as an arena for justice, it's increasingly evident that it cannot alone bear the weight of complex and urgent disputes, particularly with an environmental dimension. With its adversarial nature and inherent delays, the formal litigation process, in my respectful opinion, often fails to provide timely or holistic resolutions. By contrast, again, in my very humble opinion, mediation offers a vital and dynamic alternative. It essentially empowers parties to engage directly to explore creative solutions and to resolve disputes more efficiently. As I often say, litigation is about the dispute between the parties, whereas mediation is about the parties to the dispute. It's a subtle but an incredibly crucial distinction. It is a discipline in its own right. We often speak of mediation as an art, emphasizing the mediator's role in fostering empathy and understanding. Yet behind this art lies a robust science. And I'm delighted to inform you that I've been part of a training exercise in Lahore with the assistance of Lahore High Court Bar Association and IBA. And we had the privilege of coming across a number of lawyers, some very senior, some very junior, who wanted to train as mediators. Can I say, first of all, I was incredibly impressed with the amount of talent that you have in this country, particularly within the legal profession. And I was also impressed by the openness with which the lawyers in Lahore approach the issue of mediation, because I think they recognized that it's something that can systematically address even the most entrenched conflicts through structured methodologies, which is informed by data and psychological insight, something which Umar Sumru suggested lacks currently in this country. Now, climate change and its potential consequences is no longer a distant threat. It's already shaping legal disputes, it's challenging governance, and it's testing everyone's justice systems. The question is not whether it exists, but what we do to respond to it, not just legally, but ethically and effectively. Now, in my view, mediation is not a panacea. It's not a cure to all the ills, but it is one of the methods that one can deploy because it's increasingly used in England and Wales to resolve even environmental disputes and climate-related disputes by offering faster, less adversarial alternative to litigation. I was interested to hear earlier on about the concept of climate courts. To a judge, that should be music to my ears. But that would still involve a dispute between the parties requiring a court's adjudication. And with that, you will have the normal issues that you encounter with non-environmental or non-climate related issues. Let me give you a concrete example of how mediation has been used in the United Kingdom to resolve environmental related issues. You may or may not have heard of the London Array Wind Farm, which was once the largest offshore wind project in the world. Now, it faced significant community opposition during its planning stages. mediation helped the stakeholders, which included developers, environmental groups, and local authorities, to agree on modifications that protected wildlife habitats while allowing the project to proceed. That is one of the ways that mediation can be used to bring disparate parties together without the need for an official court process. CEDA, Centre for Effective Dispute Resolution, reports that 74% of environmental mediations that they facilitated resulted in full or partial settlement, which in my view reflects a very, or rather demonstrates its effectiveness. Now, climate disputes, I recognize, are really simple. They involve various different stakeholders, from governments, industries, NGOs, and local communities. And traditional court processes can be time-consuming, they can be costly, and often leads to a winner-takes-all outcomes. Now, in 2021, the United Kingdom Supreme Court heard the case of Friends of the Earth and Heathrow Airport, which concerned the expansion of the Heathrow Airport and its compliance with climate targets. Before the court gave its ruling, early mediation attempts helped to narrow the issues and enable the parties to focus on the litigation, which meant costs were reduced. Now, this shows, in my humble opinion, that mediation, even if it's not conclusive, can shape dialogues positively. Now, what part do we, as a legal community, play? I'm still part of the legal community, even though I've retired as a practitioner. We have a duty not to just interpret the law, but to ensure that it serves a public good. In the face of climate change, this means a number of things. It means advocating for mediation within an Environmental Protection Act framework. Again, Mr. Sumru stole my limelight by mentioning that earlier on. It involves establishing climate mediation panels, perhaps not too dissimilar to this, that are involved in training in both law and science, because that will involve greater degree of information coming out. And it also involves active participation from you and the bar councils and law schools to ensure that ADR and mediation is integrated within the existing legal education system. In the United Kingdom, we have a Department for Environment, Food and Rural Affairs, which actively encourages the use of mediation in planning disputes. Now, the UK's experience shows that mediation works. And may I say respectfully, without embarrassing my chairman over here, Pakistan's recent decisions appear to show that mediation can work here. I understand some 22 separate judgments have been given from the Supreme Court of Pakistan to the Islamabad High Court, Punjab High Court, Lahore High Court, Sindh High Court, and the others, which have included decisions from Mansoor Ali Shah and Justice Jawad Hassan. I've read his judgments in Faisal Zafar in Netherlands, believe it or not. I found them tremendously helpful and informative. And may I suggest that you go away and read those judgments to find out how mediation is viewed in Pakistan, because I believe that the potential for it is immense. I want to conclude with something which is from one of the judgments of your courts, because I think that highlights in fairly certain terms the view that your superior judiciary is taking to mediation. And I will tell you where that judgment is. Mediation bridges modern legal systems with indigenous practices, thereby strengthening communal harmony while maintaining legal validity. This is one of your judgments. Mediation must be increasingly seen as a right of the parties within the litigation process. Mediation is at the heart of access to justice. Courts must embrace it as an essential tool for efficient and humane dispute resolution. In conclusion, mediation is not merely an alternative to litigation, but a complementary and necessary component of the justice system. It then sets out the following benefits of mediation. It's cost-effective, it's time-efficient, it's flexible, it's confidential, it preserves relationships, it allows the parties to have control over the outcome, it enables expertise to be used, and it reduces hostility. That was the judgment of your Mansoor Ali Shah in the case of Mughal Pakistan Limited employees and Pakistan Real Estate Investment. This is one of your judgments. Paragraph 5 and 6. I thought you might correct me on that. And may I say, Justice Jawad Hassan has played an instrumental part in advocating ADR and mediation. One of the reasons that I'm here, and one of the reasons that Ghazan Mahmood is here, is because of the active part that he has played and the enthusiasm that he has shown towards this method of resolving disputes. And he has a clear affinity towards this method of resolving disputes. He has a clear connection to the legal justice system. I mean, I congratulate you, sir, in a very public way about the part that you have played in welcoming us to your great country, the proactive part that you've played in setting and arranging our itinerary, our schedule. We have been working to a fairly military timetable for the last 7 days.
And that's called mandatory bullying hospitality. And they said you have done the mediation judgment, which is mandatory. Now you're bullying us to make our plan. So there's not a single minute is free now. This is, I'm sorry. Well, for Pakistan.
I don't say it as a complaint. I say it as a means of congratulating you in a very public way. And nothing that I can say anymore will reduce the impact that you have played, both generally and specifically for Ghazan and myself. May I conclude with one final nostalgic reflection? 28 years ago, I started the bar vocational course in London. I was a young man from Manchester who had made his way down to London. I had the pleasure of meeting a very debonair student who had made its way from Pakistan, Karachi in particular. I learned an awful lot from him, including how chicken dansak should really be made and tasted. And may I inform you that 28 years later, I have the pleasure and the privilege of sharing this panel with Umar Sumru. And I'm really delighted that you've given me the opportunity of doing that. And I look forward to engaging with all of you during the course of the day. Thank you very much for your invitation.
Thank you so much, sir. Barrister Ghazan, if I can, have you add to it, and if you can maybe talk a bit about your background and experience into mediation and link it to environmental mediation as well.
Yes, of course. Can you all hear me clearly enough? Thank you very much. Firstly, honourable judges, esteemed colleagues, friends, ladies and gentlemen, welcome here today to this conference, and thank you for having us here. When I came here today, I wasn't expecting such a large turnout, and I'm looking around the room now, it's packed to the rafters, and I've noticed people trying to break in from the back, trying to get in, which is a testament to the quality of the talks that you've heard from all of the people on this panel so far. Can I begin, first of all, by thanking the organisers of today's event, SDBI, Sarah. Can I also thank Bulent, who was here, but I don't believe he is any longer, for his considerable hospitality, and he has been an excellent host all week. And may I, above all, thank my honourable friend here, my big brother, Mr. Justice Jawad Hassan, who you all know very, very well indeed. I second everything that Sufyan has said about him. He has provided continued support and unwavering commitment over the years to you, and indeed, it seems, to the British judiciary. It's because of his efforts that we've all come together today, and we're all here today for that reason. You may be wondering, why do you need to hear from British-based barristers or British-based judges? Well, we are here to learn just as much as you may be wanting to learn. We have insights from our system, and we'd like to learn from your systems as well. And I've been listening with great intent today to all of the people that have been talking. And I've learned a great deal. And I must say that I share many of the concerns that have been iterated by the people on this panel, particularly by Umar Sumru. He's raised a number of points that I entirely agree with. And I'm going to develop those points in a short while. Now, I can say very sincerely as a result that it really is a privilege and a pleasure to be here, talking about the evolving role of mediation in disputes, including environmental disputes. My talk is not specific to environmental disputes because I think that would be a disservice to mediation. Mediation is a universal tool. It's a universal concept. It applies across the board to all kinds of disputes. The benefits that Sufyan Rana identified earlier are the benefits that apply in every case to a larger extent in complex disputes. But as far as environmental disputes are concerned, we know there are multiple stakeholders, very complex issues, expert evidence, and therefore mediation may be more profitable in those kinds of cases in saving costs and saving time. It's precisely because of those qualities that mediation is advocated in those kinds of disputes. I've been asked today to focus principally on the UK system, and I do so not with a view to lecturing you on how well we are doing, because we have exactly the same problems you have here. The only difference is England and Wales is a much smaller country. The scale of our problems are therefore a lot smaller than yours. But that is not to say that we don't have issues as well. Secondly, of course, we have implemented mediation rules, and we seem to be a little bit ahead in time from the implementation that is now taking place here. And there's a great wisdom in collaborating and discussing ideas, because you can then see how it works with us and how it might work better with you. Now, I, like Sufyan, began my practice many, many years ago. In fact, I think I'm 1 year older than Sufyan, and I think I'm about your age. But I started my practice back in 1998 when I finished my pupillage, which was just a year before the Wolf reforms. And I imagine the students sitting at the back of the room will be well aware of the Wolf reforms and the impact those reforms had within the UK. I can tell you, when I first started my practice, the focus was entirely on litigation-based dispute resolution. Mediation was seen as clunky, cumbersome, informal, lacking rigor, and so on and so on. And for that reason, mediation didn't in fact take hold for a very long time. But following the introduction of the Wolf reforms, there was a considerable shift, a fundamental shift in litigation culture, because the reforms themselves were designed to stamp out or at least reduce the amount of cases going through the court system. So we had a new overriding objective introduced, and then subsequent to that, through judicial encouragement, there was an evolution, and that evolution took place slowly over the course of the next 2 or 3 decades, resulting in the present system, which is slightly ahead of yours in terms of mediation. Let me just summarize what the position currently is. In England and Wales, courts are duty bound to consider mediation, to propose mediation. That's the starting point, as is your system. However, the fundamental distinction is the point that my friend here, Umar, made earlier. The courts in England and Wales also are empowered to direct mediation in any case, with or without the parties' consent. Now, that's a fundamental point. Secondly, and as a consequence, all small claims matters, for example, claims worth less than £10,000, do undergo some kind of mediation process, early neutral evaluation process, to weed out cases, to discuss them, and to resolve them very quickly, which reduces the caseload. Thirdly, and I'm talking of a different jurisdiction here, in, for example, tribunal claims involving employment disputes, there is now a mandatory requirement that every single case, before proceedings are issued, must go through a conciliation process. I emphasize that's the distinction between our system and yours, in that the focus there is on ensuring that before proceedings are commenced, all parties undergo a conciliation process. Now, that is not because mediation is warm and fuzzy. In fact, it's the reverse of that. The reason for that rationale, or the reason for that rule, is because there was once upon a time a floodgate of employment claims coming through the system, and there was a need to reduce the workload. So by introducing this requirement that every employment claim must be conciliated before proceedings are commenced, it's essentially mandated people to go down through a process that they may not wish to do so, but the consequence of them not doing so is that the tribunal will then lack jurisdiction. Umar made the point before that there ought to be teeth. For example, there ought to be cost consequences. We, in fact, go further when it comes to tribunal claims, in that if you do not go down the conciliation process, there is simply no jurisdiction for a tribunal to even consider your claim. That is how severe that is. But I should say, the system we have in England and Wales hasn't developed solely through judicial encouragement, although judicial encouragement is very important. It has developed into the current state because we have a supporting ecosystem of rules which complement what we have there. And I'm going to give you just some key components of the ecosystem in the hope that it may address some of the concerns that Omar referred to and others referred to earlier. Firstly, we have codified pre-action protocols, which are very important because they require parties, before proceedings are issued in certain kinds of cases, to disclose their hand, to discuss ADR, to disclose their evidence in the hope that matters may resolve. Now, those principles in the pre-action conduct are quite important because if you do not comply with them, that even if you win the case later on, you can be made to pay costs, even if you win. So there are cost penalties. Secondly, and taking that one stage further, you will be aware that in England we have a cost paying and a cost recovering regime, which means that the winner at the end of the litigation usually recovers his costs from the failing party. Now, that's a very good system in itself, but in addition to that, judges have a discretion that if the parties have failed to engage in mediation, even if the party has won, he may be disallowed his costs. In fact, he may even have to pay costs. Now, that's quite an important sanction because it incentivizes mediation. It encourages people to go down the route of mediation instead. Thirdly, we have a professional infrastructure in place, which I believe you are developing here. Organizations like the Centre for Effective Dispute Resolution, Civil Mediation Council, they provide accredited mediators, they train mediators and so on, and they provide oversight. And that is also a very important scheme as well. So how does this impact on Pakistan? What can Pakistan do to improve its position? Let me say from the very outset, I'm not going to be so presumptuous as to assume that I have the answers. I don't, because we are in the same system. But in my humble opinion, there are certain things that you can do. Now, I and Sufyan Rana had the privilege of having dinner earlier this week with His Lordship Justice Shahid Karim. And he made a very valid point, a point that I've repeated previously. He made the point that court-led encouragement, court-led innovation can only go so far without complementary procedural rules and institutional capacity. It's the same point that I've made previously, and I think Umar made that earlier when he was referring to this, that court-led judicial encouragement is important, but you do require procedural tools to ensure that there are sanctions in place to prevent people from simply paying lip service to the concept of mediation. Now, in my humble opinion, the UK's model provides actionable insights. One might consider codifying a pre-action protocol to encourage parties to resolve disputes before proceedings are commenced. You may consider the development of a mediation panel with a list of trained, accredited mediators specializing in the area of law that you have available. You may consider, more importantly, the cost incentives that I referred to in judicial training. So in short, environmental mediation, very much like any kind of mediation in the UK, did not take root overnight. It took planning, it took rules, it took leadership, and it took sustained effort, not just from judges, but more so from lawyers, recognizing that if they do not comply with the mediation requirements, they and their parties can be sanctioned. Now, I'm not going to take up any more of your time. Thank you very much indeed for listening.
Thank you so much. Since both of you are here from England, I just wanted to ask if you can maybe just on a concluding, give some advice for the young lawyers who want to maybe develop mediation as a practice area of theirs. Any tip or suggestions you have for the law students as well as the young lawyers?
Well, I can probably address that in short terms. As Sufyan Rana said, he is here, and I also attended belatedly for one purpose primarily. We were encouraged to come by my good friend here, who set our agenda very strictly for us to be here and followed it through. But we're here for one purpose, and it's to train or assist people in training to become accredited mediators. Sufyan spent the entire week in Lahore training a number of individuals, and I had the privilege of seeing some of those individuals in action for a couple of days, and I second the point that he made, extraordinarily bright and very, very committed. So in answer to your question, my view is that I think mediation is the future. It's not soft justice, it's not a compromise of justice, it is the future. And I think over the next few years, mediation will take root more than litigation. Perhaps it will take time, but it will. So those of you who are interested in mediation ought to take training in mediation. Now, I should tell you through my own experience that the skill set for a barrister is completely different to the skill set of a mediator. And do not believe the two can be conflated. They can't. When I first started sitting as a judge in 2009, at the time, I genuinely believed that it would be a very easy transition. I was only sitting part-time, and I had been a barrister before then for many years. And as a result of that, I had honed my practice, in an adversarial way, aggressively cross-examining, making submissions. And I thought that is what made a good judge as well. Absolutely not. So it was a shock to me when I became a judge. Then I realized that I had to abandon all of those skills and listen. Just listen, observe, and gently find a way of resolving the case. Well, mediation is one step further than that. It requires trained, accredited mediators to impartially discuss matters in a very gentle, proactive way, rather than a pushy, aggressive way. It's a skill set. So in answer to your question, train as accredited mediators, and if you wish to do so, discuss it with Belent, who I believe has an approved course on that basis.
Okay. Thank you.
They're lucky they have two judges who are accredited mediators. Justice Ejaz Sak, prior to us, and me and Justice Mia Gul, we were in Singapore, were a tough course. We had to pass a very tough. 14 people went, only 5 passed. All failed. And me and him, we passed.
Yeah.
That is that he is a accredited mediator. Shah Sahab is a accredited mediator. Jawad Sarwana Sahab in Karachi, accredited mediator. Mishir Alam Sahab is the first one who gave a judgment of the SNGPL case of Orient Petroleum 2021 SCMR 1856. He is the author judge who's made the whole commercial law practice in Pakistan. So he will talk about, and then his story is related to my story. He is telling a story to everyone. When we had a first judgment, we invited him to Pindi bench last year, 15th February 2024. He said, when we started mediation, lawyers literally blew up, put the fire on all the stalls in mediation. There was huge resistance from lawyers in Sindh High Court, which is not now. It happened to me in January. When we spoke about mediation, some senior member, Shadad Shaukat and all, they came out and said, we don't believe in mediation. And then I had to tell them in a tone which I said now, that this is the solution now. Now, this time they came to Lahore and I came here cowardly. I don't want to face Lahore bar, but they literally taken care of. So this is how you have to. Islamabad is very good bar. You have the judges very well. You have the system very well. You have a system because everybody is focusing on you. But what are they focusing on? A bar of 0.9 million people, a bar which has only 2,000 square mile. Rawalpindi in Punjab is 142 million people in Punjab, 42 districts. I'm a judge in Pindi bench. Pindi bench is 26 million people, 9 districts, 42 tehsils. Huge. It's like a country of European 3 countries together. And the kind of litigation we go to, we're trying to do a lot of mediation, which you should see on Monday, all successfully done. Nasir Mujahid Saab is handling a lot of mediation on my behalf, and he's doing it. 2, 3 failed, but mostly are passed because you have to have a Harvard approach of PON, Project on Negotiation. Every week say, what is the issue? I'll give you a reality check. You have to have that tone now. The judge who has a command on court can only command on mediation. If you don't have a command, don't do mediation. But you have to take a confidence on parties with your reputation, with your judgment writing skills, with your sharp mind. Then they agree because these lawyers are very fast. They say, no, don't do it. Leave that judge. Lawyers are the one who always destroy that. That's what I'm saying. Yes.
The whole bar, huh? The whole bar.
No. Every law in Pakistan has a preamble. Family Court Act says a law to provide the settlement of family disputes in Pakistan, including SSGP law says an act to provide for company matters to have an effectual resolution of corporate disputes. So when the word is used under Article 37, sub-Article D, it says effectual. So what we do is when this case comes to court, it's a court's duty to say, do I need to waste time? And mediation is, you are the judge. She is the judge. Difference. Arbitration is different. Arbitration, because ADR means alternate dispute resolution. I've shared an article of Tallah. Though that's a German of Vikas Jabal, we have strengthened that ecosystem. We are strengthening the ecosystem of ADR, judges, lawyers, centers, practitioners, general public. So ADR means arbitration, which is have to be mandatory. There has to be a dispute clause in the clause. It has to be in writing. There's a judgment for first time in Pakistan. I wrote PLD 2021 Lahore 398. That you cannot send oral arbitration matter. You have to have a in writing prior clause of an arbitration, forum of arbitration, and once you do that, then you can send to a matter of arbitration, because arbitration is prior to a stage of coming to a court. Understood? Hands are tied. That's to PLD 2021 Lahore 398. And now the question is, then comes from arbitration is the arbitrator, and that could be forum. Then comes the reconciliation. Reconciliation is there is a concept between which is bit kind of a hard and soft too, where you reconcile the matter through a forum, which is now. Third, which I have started, a regulatory mediation. A regulator can do a mediation together, and then mediation is mandatory or evaluative or facilitative. Sometimes you just facilitate parties. Okay, just talk to each other. Sometimes, no, I know the case very well, I'll give you. But mediator can't give you a suggestion. They can only make you sit down. In the first case which I did, Faisal Zafar, it was a tukka. Parties came to me and said, Nadeem, you have dyed your hair as orange, you have white hair. Take them to PC, sit down together. The two Pathans and Punjabis were fighting over a pharmaceutical company. Huh. Huh. I agree with you. If a judge is involved with mediator throughout, and he's a trust on mediator, because mediator is the voice of a judge. I can't see, but no. But those mediators we fail where you did. I keep on case every week. Yes, what happened? Have you done the mediation? What is the issue now? Sir, we have done all part. 10% is left now. Okay, let me give you now a reality check. If you don't agree with me, when you go to Supreme Court, 2024 SCMR 1434 Ashim Malik judgment, that we are not a second appeal of High Court. This you see the cost Supreme Court will impose on you. Sir, my lord, okay, we do the mediation. You have to give them a Supreme Court judgment on this. That if you don't listen to me, either party will go to Supreme Court. And you know what? They come back to it. He will tell you a success story. Every day, see how many stories. Two gentlemen fighting, two parents are fighting, but everybody is fighting and resolving it. Nisar sahab bade mashhoor aadmi hai senior bolte.
Sir Sufyan, if I can, sorry. I won't mention my age. Wonderful. Sir Sufyan, just on a concluding point, if you can also give some advice.
I'll say two things. ADR means alternative dispute resolution. I think lawyers think it means alarming drop in revenue.
That's a good one.
I don't think you need to think about ADR as an alarming drop in revenue. Think of it as just another way of resolving a dispute. I'm now a judge, but I was a lawyer like you. As a lawyer, my job was to find solutions to problems and hopefully get paid in the process. Mediation is a tool through which you find solutions to problems. If you resolve a case, you will have time to do other cases. And with other cases, you will earn even more money. So there will not be an alarming drop in revenue. There will be an increase of revenue. So don't think of it as Turkey voting for Christmas, because you're not going to be affecting your livelihood. If anything, you're actually adding to your livelihood. Mediation is quite an intense course. It's not just a case of getting two people together to say you need to reach a solution. If it was that case, it would take 5 minutes for the course. But it's a 5-day course and you're taught different techniques. You're taught to understand the parties to the dispute, not the dispute that divide the parties. I said this in my talk. It's a subtle but an incredibly crucial distinction which good mediators work out. My second point is this. We are giving back to you a system that you have given to us. You've had a panchayat system, you've had a jurga system for a lot longer than we've had mediation systems in Europe. So don't be scared of something which is part of your history, which is part of your culture, which is part of your heritage. If anything, it should be the easiest thing for you to be able to do. We are simply giving you something dressed up in a European way in the hope that you might buy it. Please don't do that. See it as your own system. See it as your own tool to resolve disputes. Thank you.
Thank you so much.
What will be difference in UK mediation and Pakistan mediation?
None. Because the techniques to resolving disputes are the same. You have to understand the parties to your dispute who are Pakistanis like you. Try to understand them, you'll try to understand the dispute, and you'll try to find a solution. I try to do that, well, I don't do it anymore because I'm a judge, but when I was a mediator, that's what my aim was. I needed to understand why the parties have come to the point where they're in a dispute with one another. Yeah, okay.
Thank you so much, sir. So that brings, the close of the second roundtable panel that we had. I did want to invite the president of the Islamabad High Court Bar, Sayyid Wajid Ali Girani. He's here, along with the secretary of the Islamabad High Court Bar as well. They've been very supportive, and when I pitched them the idea about this, they were like, consider this as your bar. So I've thoroughly enjoyed working with them. And so if I can have the president to give his closing remarks.
Bismillah ar-Rahman ar-Rahim. Allahumma salli ala Sayyidina Muhammadin wa ala ali Sayyidina Muhammadin wa barik wa sallim wa salli alayhi. I am honored to be a part of this program as a president of Islamabad High Court Bar Association. And as we draw this important session to a close, I want to express my heartfelt gratitude to all our speakers, panelists, and participants for their time, insight, and commitment to the cause of climate conscious lawyer. Today, we did more than just talk. We opened a door of collaboration to education, and to rethinking how the legal profession can serve as a force for environmental justice. Whether it was through reflection from the judiciary, policy, perspective, and comparative insights from international jurisdiction. Each contribution had added to a growing body of knowledge and responsibility that we must now carry forward. This message is clear: climate change is not someone else's issue. It is our, and as legal professionals, we must raise to meet it through stronger legal framework, through proactive mediation, through education, and powers to next generation of the lawyers. Thank you very much.
Thank you so much, sir. If I can request Justice Mashir Alam as well to, you've attended the whole event, so if you can maybe summarize for us and give your thoughts.
Bismillah ar-Rahman ar-Rahim. It's really taking me by surprise. I was just attending it as a participant and I was given the chair. I'm so grateful to Mr. Sulairi and Justice Jawad and honorable members on the podium. It's a great honor to be amongst you. As Mr. Somro has pointed out, that lawyers are not driven by change or not receptive of change. They are a formidable challenge. And this is what Mr. Somro has pointed out. I was one of those judges who was laid out in 2007 during a very tough regime. And amongst large number of judges who were laid off, I was one of them in 2007. But as God has its own way and design to conduct things and manage things. And I think it was an opportunity for me because at that time, World Bank has initiated ADR project in Karachi and established first dispute resolution, Karachi Dispute Resolution Center. And I happened to be one of its founder director to take it into the fold of mediation. I myself was not very supportive of mediation or alternate dispute resolution mechanism. I was a hardcore lawyer and I had a mindset of conflict, creating conflict and thriving in conflict. Fish cannot live without water. A lawyer cannot live without a dispute. So that is the way, one way I found I sailed through mediation. I attended a number of international events representing Karachi Center for Dispute Resolution. Fortunately, I was restored in 2013. Again, thought it has given me an opportunity. Perhaps in 2009, I was restored. And I climbed towards the Chief Justiceship of the Sindh High Court in 2011. I got an opportunity again to hammer on the lawyers that what I have learned is ultimate and you must follow it. And that was a hardcore approach. And I believe that was a wrong approach. We should have educated the lawyers. We should have trained the lawyers. I had the chance to visit UK Center for Effective Dispute Resolution. And I was amazed to see that the center was sitting in the court. And I was surprised in Pakistan. No NGO would be allowed to sit in the court and assist the court in working and facilitating the court. That was the first interaction with the Center for Effective Dispute Resolution. I thought I am a very wise man. I can enforce mediation in the court. When Small Causes Court was done away in Karachi, I found a very effective, beautiful place in the old district court building. I established mediation center, thought that lawyers would be welcoming it. But to my surprise, the day I inaugurated the Court Annex Mediation Center, the other morning I found out everything was thrown out of that mediation center. Lawyers reacted very harshly and sharply. And across Sindh, there was a strike that here a new mindset has come who is determined to spoil the practice of the lawyers. And that really broke the heart. But it was never stopping journey. It continued. And I am happy to see all of you here pro-mediation, at least trying to learn what mediation is. And certainly Justice Jawad, Justice Mansoor Ali Shah, and our proactive judges in Sindh, Punjab, they have given plethora of judgment. And they've gathered UK mindset to share with you. That is a success story. When I was in England in 2006, perhaps, I was told that wolf reform took 30 years to make it acceptable to the lawyers in UK as well. They have through a journey, but I believe we are here to learn from each other. And I'm so thankful that they have created and cultivated new mindset and new lawyers. And certainly they are more prone to mediation. And I wish Sulheri Saab should have arranged this event at a much larger place to house more people, more lawyers, more brains to learn from the galaxy of the speakers. I'm so thankful this event indeed would pave a way for furthering cause of mediation and promoting the cause of justice. Thank you very much.
Thank you so much, sir. So just on a closing, I will let Dr. Abid Suleri just say a few words as well. But I wanted to also thank SDPI for hosting this in collaboration with the Islamabad High Court Bar. I think it's all the participants really have truly made it a success, and thank you to all the panelists as well. Just before I let everyone go, just a quick announcement. First, I think SDPI was passing around some sort of an attendance sheet. So if you can just put in your email and name, that would be great. It would allow us to follow up with you as well. If I can request the panelists to just stay for a couple of minutes for a group photo op, and the guests are requested. There's lunch being served outside, so you may go outside and then you can come back in, or I'll let Dr. Okay.
लेकिन सर की बात का सिर्फ एक जवाब, Malad, you have started this in 2007, but right now you have Islamabad Bar Council, President Islamabad High Court Bar, President District Bar, who was also here. We have Court Annex Mediation Center in Islamabad. We inaugurated 2 days before the mediation center in district courts as well. So we are following you, sir.
Thank you very much.
रमीना, अगर आप मेरे साथ शीट दे सके। अगर शीट दे सके मेहमानों को हमारे साथ
बात कर लो। पिंडी आना पंडे बुला लो ना, चला मंडे को है हमारे पास, बहुत बड़ा कर रहे हैं वो गाड़ी
This is what a brief journey. Pioneer, I cannot claim there were the people who were driving it.
जगह थोड़ी कम है, मैं एक एक करके बुलाता हूँ। शीट्स आपको
काफी आते हैं। अब बता दो ना, इनविटेशन का सेंटर का इनविटेशन दे दो ना यार।
As I say, the greatest thrust upon me, I didn't know what the situation was that.
When it's rusted off, only means that
I don't know. And I cannot
when it's not, it means that it's been manipulated.
Chairs पे पीछे कर पाओगे तो that we can sit on the stage. Sorry sir, वो confusion होगी। नोट में ये सर्कुलेट कर रहा था कि पैनल के लिए लंच जो है वो नीचे है बोर्ड में। मैंने मुझे एहसास हुआ कि कहीं आप ये ना समझ रहे हो कि टाइम कम है, आपने जल्दी खत्म कर दिया। we were
नहीं खत्म।
no we were hoping, मैंने इनको 30 का लंच का टाइम दिया।
बस नहीं मैं
जी हाँ जी जवाब
जवाब साहब
नेक्स्ट क्या यार, ये जो तार के दो ये प्लास्टिक की कढ़ाई के ऊपर प्लास्टिक उतारो सब कुछ। ब्रिगेडियर गजन
आप
जी गजन साहब सर सर आइए। सर अब साथ हो जाइए। Justice Rana. Yes, that's the most souvenir.
No, the license.
Thank you. Next. Dr. Permission. Thank you.
Thank you so much.
Mr. Manzoor Ahmed.
Jaja sir. ਤੁਹਾਡੀ ਵਜ੍ਹਾ ਨਾਲ ਫਿਰਾ ਲੱਗਿਆ ਸੀ ਅਸੀਂ ਤੇ ਗਿਲਾਨੀ ਸਾਹਿਬ। Thank you. Next.